please. All right, I'll remind everybody, turn off your cell phones if you have them, if you haven't already. All right, ladies and gentlemen, jury services may be strange to some of you, and so a short explanation is in order before we commence the trial. Those who participate in a trial must do so in accordance with established rules. That's true of the witnesses, the lawyers, and the judge, as well as jurors. Now, the lawyers will present the evidence according to the rules. The judge enforces those rules and determines what evidence may be admitted under the rules and the law. Now, as jurors, you will be the sole judges of the facts, the credibility of the witnesses, and the weight to be given to the testimony. And at the end of the case, the court will instruct you regarding that law, and you will apply it to the facts. It's your sworn duty as jurors to accept the law as given to you by the court. Now, the procedure for the trial will be as follows. First, the attorneys will outline what they expect the evidence will be. These are called opening statements and are not evidence, but simply a preview of what they believe the evidence will be in order to help you follow it during the trial as it is presented. Then the state will offer evidence. After the state offers the evidence, its evidence, the defendant may, but is not required to offer evidence. If the defendant does present any evidence, then the state may, but it's not required, to present what's called rebuttal evidence. The trial will then conclude, and the court will instruct you on the law at that time regarding the case, and then you'll also hear closing arguments from the attorneys, and then the final instructions of the court regarding deliberations. And then after that, you'll retire to the jury room and deliberate on your verdict. Now, the procedure that is followed for questioning witnesses is as follows. The party that calls the witness will ask questions first. That's called the direct examination. And then the opposing party can ask questions, and that's called cross-examination. After cross-examination, then the party that called the witness may, but is not required, to ask additional questions, although it is limited to those matters that were testified to on cross. And that's called redirect examination. Jurors are not permitted to ask questions, in case you might wonder. Now, during the trial, the attorneys will likely make objections. That's the method by which a question of law is raised that the judge has to decide. And then they'll come up to the bench and we'll talk about it. Well, maybe or maybe not. Sometimes they do, sometimes they don't. Now, the court and the judge is required to follow the laws that are prescribed by the state of Ohio and the Supreme Court regarding rules, and applies that to the question of whether the objection is sustained or overruled. If I say that the question is sustained, then that means that I've determined that either the question or the answer or expected answer or both are not permitted, and you'll not hear it. If I say overruled, then I've determined the question and the expected answer are proper, and then you will hear that evidence. Now, occasionally, a witness will answer a question before an attorney can get their objection out. And then once the objection is considered by the court, if it's sustained, it means you should have heard what the witness said. So in that situation, either at that time or at the end of the case, or both, you'll be instructed that you're to disregard that testimony, or it may be that one of the attorneys will ask the court to strike that, and that the court will say it's stricken. So what that means is this: you're not permitted to consider it in your deliberations. Now, we know you're not computers where you can hit delete and erase it, but if somebody should bring up that particular testimony that was stricken, or you were told to disregard, you simply have to remind them that no, we're not permitted to consider that. Now, it's important that you be fair and attentive throughout this trial, and during the breaks, including lunch breaks and overnight, if that occurs, you're not to discuss the case among yourselves or with anyone else. Now, if you're someone who texts or is active on social media, don't do that regarding this case. You can do anything else, but not about the case. Not to put anything on any social media that you're involved in jury duty or anything of that nature, nor to look up anything that you might hear about the case. You're not permitted to allow anyone else to discuss it in your presence. So if you go out for lunch, or if you're out walking down the hallway, or somebody starts talking about it, just say, look, I'm on the jury, please don't discuss that, or just move away so you can't hear them. And it's important for you to understand, and maybe a little bit more difficult to understand, that you're not permitted to discuss it among yourselves. And the reason for that is this. You might say, well, we're the jurors. Well, yes, but if you're in just one or two of you are talking, that's not the entire jury, and you cannot discuss it until the case is complete, because until you've heard everything, opening statements, the evidence, the law, and how to deliberate your verdict, or reach your verdict, deliberate and reach a verdict, you don't have everything that's required for you to follow the law to make a fair and impartial juror. So it would be improper for you to discuss that, even as we go. So during breaks, don't go back and say, well, what did you think about witness X? Or what did you think about what the judge said? You don't discuss any of that. Now, it's also important that you explain this to your family and friends, if any, that if you have any contact with any of them during breaks, or again overnight, and instruct them that you're not permitted to discuss it. And I know I've examples in the past where people said, well, I served on the jury and I could discuss it. Well, once the case is over and you're discharged, then you can discuss it. But their memory's just not very good, because they were not permitted to discuss it while the trial was in progress. Now, you're not to talk to the attorneys, parties, or any witnesses that testify, or any other person about the case, and they're not to talk with you. Now, if by chance something should happen that you hear something like that, or somebody says anything, again, just tell them, look, I'm a jury, please don't do that. Now, you're not permitted to investigate or to obtain any information about this trial outside of the courtroom through the witnesses and the evidence that's admitted. So you're not to do any kind of investigation. You can't look anything up on the internet. You might hear something mentioned. You'd say, well, I'd like to know more about that, or that doesn't seem to be what I recall. I want to see if that's right. Can't do that. You can't go on the internet and look up anything about this case. It's improper. You're also not to read, view, or listen to any report in any media, whether it be newspaper, radio, that will make radio or television, but internet or social media. People do post about things almost in real time sometimes, and I don't know if that will happen about this case, but don't read anything about it. If you see anything on social media that mentions the case or any names that you've heard, do not read it. Because the people that are posting or even reporting, they're not jurors. They don't have any obligation to only consider the evidence that's admitted and to follow the law. They're basically media, newspapers, and they're reporting what they think is of interest to them and the people that are reading. And media people on social media, there are some websites that are news sites, but there's also people that just want to tell everybody. They want to tell us what they think, whether we want to hear it or not. And so you're to disregard that. Now, in the event that you should accidentally be exposed to something like that, or hear somebody saying something about the case, report it to the bailiff. Bailiff will report it to me, and then I'll discuss it with attorneys, and we'll address the matter. Occasionally, that may require you to be questioned to determine exactly what it was on the record and whether or not you can be a juror. And when I say that, to report it, do it on your own. Don't ask anybody else for any advice. And don't go back and wait for another juror to say, well, I heard this. Is this something I should report? And the example the most memorable example I have of it is about 30 years ago. We were trying a case. It was a 5-day case. Had 12 jurors and 3 alternates because of the length of the trial. During lunch, one of the alternates ran into somebody over at the old McGee's across the street, and that person knew what was going on and started talking. And so the juror told him to quit and eventually moved away from him. But instead of reporting it to the bailiff, that juror, and I don't remember if it was a male or female, came back and talked to the other 14 jurors. And they said, oh, yeah, you need to report that. Well, we had to bring that juror in, but then because they had talked with the other 14, we had to bring in all 15 jurors. It took us about 2.5 hours, so we wasted an afternoon of trial. Spent, I should say, it wasn't wasted because it was necessary. But we spent an afternoon of trial questioning jurors instead of getting evidence. So it extended the trial. So that's why I say, do not ask anyone else their opinion. Just err on the side of caution, tell the bailiff, and then we'll address it. All right. Now, we're going to, and also, you will see some bench conferences as you already have. I'll ask attorneys to come up, or they may ask to come up and talk to the court. Sometimes that's about an objection that's been raised, and the purpose of that is to allow them to put on the record what the reasons why the objection is valid or not, and what the answer may or may not be. And if ultimately I decide that it is not admissible, then that way you don't have to try to forget other stuff that the court did not permit. So it's just one less burden on you. And also, there will not be any note-taking permitted since this is a trial of short duration. All right. Now, you're going to hear the opening statements next. Opening statements are not evidence, as I've indicated. They're simply to allow the attorneys to tell you what they believe the evidence is going to be, so that it'll help you understand the evidence and the issues as the testimony is presented. Okay, so the State of Ohio will go first. Ms. Collins.
May it please the court, Mr. Arnold. Ladies and gentlemen of the jury, today the state will prove that this defendant, Timothy Campbell, did cause serious physical harm to Shane Flagger on February 14, 2025. In late 24 and early 2025, the defendant said some pretty nasty things to Shane. Shane is retired from the military and he teaches the Cadet Corps, or ROTC, at McLean. The defendant decided that Shane's military uniform and his status were something to make fun of. He called his uniform gay, called Shane a faggot. The defendant did this on more than one occasion. On each occasion, the defendant approached Shane, used some inappropriate language, made fun of his uniform, and called him a faggot or called him gay. On February 14th, 2025, Shane and his wife Jennifer went to the VFW. Now, at some point in the evening, Jennifer went to the bathroom and that left Shane sitting at the table alone. At that point, the defendant approaches Shane. The defendant said he wanted to talk about when he called Shane a faggot. Shane calmly and quietly told the defendant, "This is not the time, this is not the place to discuss this, I don't want to talk to you." The defendant doesn't like to be told no. He became enraged. He told him, "I'm going to smash your fucking head through the wall." Rather than walk away, the defendant then hit Shane. He hit Shane more than once. He hit him in the face. He hit him in the head. Shane was sitting down with his back against the wall, and his head bounced off of that concrete wall multiple times as this defendant pummeled him in the head and face. There is no question that the defendant did this. There is a video of the beating. There are also witnesses that saw this. As patrons of the VFW saw what was happening, they quickly took action, as often happens in the bar, and they got the defendant away from Shane. But this defendant hit Shane so hard that Shane was knocked out of his chair. He was on the floor, he was bleeding from his nose and his ears, and he was unconscious. Shane's wife, Jennifer, who is herself was a combat medic, got Shane awake and took him to the Greenville Police Department where a report was made. Shane went to the emergency room for treatment. He suffered a broken nose, had to have stitches due to a cut on his ear. He suffered a sprained neck. He also suffered a severe headache from the beating and his head bouncing off that cement wall. When the headache didn't subside, Shane went to the VA hospital in Chillicothe, where additional scans were taken with concerns for his back. Those scans will show that Shane suffered a fracture in his nose. Medical records will show that stitches had to be administered and that Shane had a sprained neck. The video and witness testimony will prove that this defendant was the aggressor. Shane never moved. Shane never threw a punch. This defendant repeatedly hit Shane, and Shane did not even raise his hands. The who, what, when, where, and why are easily proven in this case. The only real issue for you to decide is if Shane suffered very serious physical harm from this beating. Now, there are multiple definitions of serious physical harm, but the question to focus on is if a broken nose, stitches, and a sprained neck are physical harm that involves some permanent disfigurement or some temporary disfigurement, or is physical harm that involves acute pain. Anyone who has had a broken nose or stitches knows how this feels. They know of this acute pain. At the end of the day, there's no question that this involves acute pain and suffering and is a temporary serious disfigurement. The other issue that must be decided is if Tim Campbell was acting in self-defense. When he walked across the bar, approached Shane, told him he was going to bash his head into the fucking wall, and then began punching him in the head and face repeatedly. The idea that that is self-defense is laughable, and the answer is a resounding no. Now, I'm confident that after you hear the testimony from the witnesses and you review the tape, the video, and evidence, you will come to only one conclusion. This defendant, Tim Campbell, is guilty of felonious assault. Thank you.
All right. Mr. Arnold, on behalf of the defendant.
Yes. Counsel, Your Honor, ladies and gentlemen of the jury, what happened a month or two before was that Mr. Flagger went up to my client and accused him of looking at his wife inappropriately. At that time, the evidence is going to show that Tim was with his fiancée, and he told him, dude, buddy, I'm here with my wife, and I thought you were gay. That's the evidence, okay? So I don't think it's disputed that on the 14th of February at the VFW that Tim went over to apologize for whatever occurred there for the comments. He was greeted with, fuck you, get out of my face. In which time Tim says, buddy, you better watch who you're running your mouth to, because somebody's going to run your head through a wall. At which point, Tim was greeted with, fuck you, get out of my face. And the evidence will show that he postured in his chair. This wasn't a low chair, this was a high bar. And Tim hit him. He hit him, I think, 3 times. They weren't long crow hop punches, they were just jabs, close range. That's it. And he walked off. Okay? So, whether or not that justifies it, the fact that he had been threatening to him before and then all of a sudden became combative a second time would justify Tim's reaction at that moment. You're going to hear other circumstances that you will consider that might convince you that there's a reason Tim didn't want to get hit first, and you'll hear that evidence. This whole serious physical harm thing is going to, she's right, it's going to come down to whether or not you believe there's a serious physical harm. I can tell you that he denied an ambulance, drove himself to the police station first, not medical care. He did have a non-disclosed fracture of one of the nasal bones, which is inside, non-displaced, meaning it didn't protrude or become deformed. That he never needed treatment for that part of his injuries anyway. You'll hear that. He did have a 1.3 centimeter cut on the outside part of your ear here, which took 4 sutures. And the evidence will show that he had a abrasion on his nose as well, a 3-millimeter abrasion. And you'll hear from the emergency room doctor, I assume, as to what he found. The evidence will be undisputed. This occurred at about 10:30 at night on the 14th. At 10 o'clock, between 10 and 12 the next morning, Mr. Flagger was at a military ball with his wife. The evidence will show that later that day, after the military ball, he went to the high school basketball game around 1 o'clock. The evidence further going to show that somebody that knows Shane is going to testify that Shane, other than the scratch on his nose and the cut on his ear, looked normal, walked normal, talked normal, nothing unusual. It wasn't until 3 days later that Mr. Flagger went back to the VA, and all of a sudden he's got all kinds of complaints. He's got complaints in his lower back, neck, headaches. But you'll get to hear what the complaints were at the time of the incident that night, which are not the same. And you also get to hear about his prior medical history. You'll hear about that as well, which is pretty extensive. The evidence will show that as soon as my client, well, let me tell you this, the police didn't even go looking for Tim. It was late. They went and looked at one bar to see if they could find him because the Shane Flagger told them he might went to another bar. They went there, and that was all they did. They didn't go to his house. They looked for him. My guy calls in the next day and says, hey, anything I need to know about? He said, yeah, we got a warrant for you. He went and turned himself in. He didn't run. Operative. So he called the police to find out if there was a charge or anything that was going on. I'm going to ask you, and I talked about this in voir dire, that just please wait until you hear all the evidence. Because what you were just told could be a first impression that would say, golly, he bashed his head into a wall. Well, guess what? He didn't have any complaints in the back of his head at the emergency room. None. And he didn't mention a fall. He had mild pain, non-traumatic in his front of his head. You're going to hear evidence that all of the CAT scans of his brain, his neck, his thoracic spine, his lumbar spine are all negative. Nothing. All his cranial nerves, head nerves, fine. So, at the end of the day, I don't believe the evidence can support a conviction for felonious assault. My client used his hands. He didn't use a bat, didn't use a gun.
Objection, that's not the law.
Yeah, he's not charged under this section, Mr. Arnold, so keep your argument confined to the statute in question.
My client is accused of causing serious physical harm, knowingly causing serious physical harm. I contend the evidence be that there's no possible way that Tim would have known Mr. Flagor's medical conditions.
Objection, that's not the law.
It is the law.
Wait a minute. You want to sustain it and not to argue the case. You're arguing now, not presenting evidence.
At the end,
open statement, I should say.
So at the conclusion, you're going to have three options. One, was Tim justified? If you find yes.
Objection, that's not the law.
Okay, approach. There's some bench. Okay, justified.
I'll just reiterate, I don't believe the evidence is going to show serious physical harm beyond a reasonable doubt in this case, ladies and gentlemen. I thank you for your time. It's important to me. I thank you on behalf of Tim and myself.
All right, thank you. Collins, your first witness.
Dr.
A motion for separation of witnesses.
I would move.
I move.
All right, so those, anyone expects to testify is excluded from the courtroom other than the state's representative who's sitting at the table. And you'll need to police that yourself since I don't know those people. All right, your first witness.
Dr. Barker.
You say Don D. Palmer?
No, I said Dr. Barker.
Okay, Dr. Barker. All right. Have you been sworn in the clerk's office?
I have.
All right, we are broadcasting this and it could be photographed or printed off the internet. Do you have an objection to that?
I prefer not.
All right, this witness will not be broadcast anything. I have a seat over there. If you have a phone, make sure you turn it off. Right there.
Your Honor, may we approach?
Lieutenant, if you would, pull the microphone. That's a microphone there, so pull it as far to your left as it'll go. And just make sure you speak into it. All right, counsel, you may approach. All right, you may inquire.
Thank you. Please state your name for the record.
Darren Barker.
And are you currently a physician?
I am.
And where are you a physician?
Dean of Greenfield Medical Center.
And what do you do there at Dina Greenfield Medical Center?
I work in the emergency department as a physician.
And do you have a primary focus? Is that your primary focus in medicine?
I'm board certified in family medicine with my focus is emergent care and acute care.
And
urgent care.
I'm sorry.
And urgent care.
As part of your job responsibility, well, let me ask you this. How long have you been employed with Adina in the emergency department?
About 9, almost 10 months.
Okay. Were you employed in an emergency department or emergency medicine somewhere else prior to that?
Correct, ma'am.
And as part of your job responsibilities, were you working in the Adina emergency room on February 14th, 2025?
Yes, I was.
May I approach the witness?
You may.
I'm going to hand you as previously been marked as State's Exhibit 6 for identification purposes. Do you recognize those? You can move the CD off the top.
Yeah, these appear to be my medical records.
And have you had the opportunity to review those records prior to testifying today?
I have my notes.
Okay. And do you recall Shane Flyber coming into the emergency department on that evening?
I do, primarily from my notes.
Okay. On the top of those medical records, the front page, the very top page, is that the certification that those are true and accurate copy of the medical records?
Yes, ma'am.
Okay. Now, what was the purpose of Shane coming into the emergency department on February 14th of 2025?
He was injured in an altercation.
And how did he look? What did you observe about him when he arrived?
He had a laceration to his right ear. It had some bleeding. He had an abrasion to his nose, some facial contusions, mostly to the nose as well.
And did you treat him for some injuries?
I did. I ordered a CAT scan. I repaired the laceration to his right ear. I gave him an injection of Toradol for pain. He was also complaining of a headache, so Toradol was appropriate for that.
Let's talk. I'm going to refer you to page 13 of the records. Let's back up. You said you ordered some scans?
Correct. CT scan of his head, facial bones, and neck.
Okay, and according to page 13 of the records, what were the findings from those scans?
Would you like me to read it, or just from my?
Just
Yeah.
your number.
The CT facial bone scan showed a non-displaced fracture of the left tip of the nasal bone.
And
Correct.
Okay, what steps were taken to repair that?
So the laceration to the right ear was repaired by myself. It was thoroughly cleansed prior to that by nursing staff, and then injections of lidocaine, and then I believe 4 sutures for closure.
Is the place where this laceration was, is this an odd place to put stitches in?
It was, yeah. It was more in the helix, the anti-helix of the ear, which is kind of this part of the ear, or about that part of the ear. So typically we get lacerations to the earlobe. It's a little easier place to repair. So this is a more challenging area to repair.
You also mentioned the fracture to his nose. Was that fracture repaired?
Not in the emergency department. I don't have any knowledge of what happened after he left.
So the fracture that was in his nose remained when you were finished with him?
Correct.
Now, according to page 14, there were some other diagnoses made. Do you recall those?
Besides the laceration, there was an abrasion to the tip of the nose. I think post-traumatic headache was one of the diagnoses. Cervical sprain.
You mentioned it. You said cervical sprain. Is that a neck sprain?
Correct.
Okay.
Yes.
And was Mr. Flyger complaining of pain there when he came in?
Yes, he was. He was complaining of some neck stiffness, I believe.
When you talk about a neck sprain, explain what that is.
Well, anytime I can go into more detail about the CT scan if you would like. I do have knowledge of that, but a neck sprain is where you forcibly either are thrown against a wall, fall down, you're in an automobile accident, but you have a whipping motion of your neck, which typically causes that.
And that's what Mr. Flyger suffered?
Objection, Your Honor.
Overruled.
I'm sorry. You can answer.
Correct, yes.
And is that painful?
Yes.
And does it restrict your movement, things like that? Your movement of your head?
It's variable, but some neck stiffness would, be presumed.
Dr. Barker, you previously served in the military? Or
Still, I'm actively serving. Yes, ma'am.
In your service with the military, they train you to kind of put up with pain?
I believe so. I mean, there's some pretty rigorous things that we go through in the military, combat, things like that.
I have no further questions.
Cross.
Yes, Your Honor. You made reference to your notes. Do you have those with you?
Right here.
Are those the ED provider notes?
They are.
Okay. And I'm going to show you what's been marked as Defense Exhibit B, which appears to be different than what was Exhibit 6. You've looked at Exhibit 6?
I have 6 here.
Okay. May I approach the witness?
You may. Pardon me?
Do you want a copy?
Not yet.
I'm going to hand you what has been marked as Defense Exhibit B. Is that contained in the state's Exhibit 6? Or first, can you identify the...
This appears to be my note from that evening or night.
Okay. Okay.
Which page was that, 14?
Yeah, February 14th. Is that
No,
what you
it's
have?
not page 14.
No, that's the first page of Exhibit B.
First page?
Yes.
Okay.
Okay. I'm going to walk you through your notes that you referenced earlier, just maybe might refresh your memory a little bit. You took a history when Mr. Flygore came in, right?
I did.
And other than an issue with a heart valve or something, he never mentioned that he had cervical disc disease.
I'm going to object.
Let's sustain that. We're not here to talk about his general health, we're talking about the alleged injuries, so.
Your Honor, Doctor, you mentioned that neck stiffness can be caused from an accident or a whiplash or something, right?
Correct.
Could also be caused by degenerative changes?
Correct.
Okay. The history that you got from him, well, let me back up. When you take a history, you can only rely on what the patient tells you, right?
Yes, sir.
Subjective information.
Correct.
Headache, stiffness. All right. So he also told you that he lost consciousness for less than a minute. Remember that? That's in your notes?
Yes.
Okay. He also never mentioned to you that he was in a fall.
Could you repeat that, sir?
He never mentioned to you that he was in a fall. F-A-L.
That he fell.
Right.
From my note, and I can read it here.
Yeah, please.
He was knocked against the wall and was witnessed to be unconscious for less than 30 seconds.
So the answer is he did not say he fell. Right.
Well, if he was unconscious, he would have been.
Well, you're just assuming that.
Objection, he didn't let him finish.
Yeah, let him finish his answer before you interrupt him and ask another question. Go ahead, finish your answer.
Yeah, I think, again, if he was knocked against a wall and then witnessed to be unconscious, unless someone caught him, which I didn't put in my note, he would be laying on the floor at that time.
Okay. Are you finished with your answer?
I am.
Okay. You're just assuming that he fell to the floor.
I am.
Okay.
According to the
Thank you.
notes, it's presumable.
I want to go through the review of symptoms that you have on that page 1 of Exhibit B. Negative for activity change, chills, or fatigue. Yes? These are your review of symptoms?
Yes.
Systems. Negative for congestion, negative for cough or shortness of breath, negative for nausea, right?
Yes, sir.
Positive for neck stiffness, but no pain.
I didn't put no pain. I put positive for neck stiffness. I believe was what his complaint was.
Well, are you done? If your patient told you had neck pain, you would have noted it, right?
I believe if you skip to my physical exam, there was tenderness when I palpated his neck.
Okay.
Paracervical tenderness, I think was my exact
So,
words.
maybe I used the wrong word. So he had some tenderness, not pain.
Yeah, I mean, to me, it's very similar.
Okay.
Tender. I would call that pain.
Okay. You talked about the wound. You said positive for headaches, but negative for facial asymmetry and weakness. Can you tell us what that is?
So I didn't ascertain, when people sustain head injuries, potentially, we look to make sure that their face looks symmetrical, meaning typically no droopy eyes, no droopy mouth.
Okay. So you didn't observe anything, his face was normal looking, other than the cuts?
Other than the things that I've already mentioned.
Yeah, okay.
Yes.
If you go to page 2, at the very bottom of Exhibit B, physical exam, constitutional and general, he is not in acute distress.
Correct.
He was not. Okay. Turn the page to top of page 3 in your notes, Exhibit B, appearance, normal appearance, period. He is not ill appearing, period, right?
Yes, sir.
And that was the case. Okay. What is, come down to head, it's, what's that term that you use there, how do you say it?
Paint?
Normocephalic or something like that? Yes?
Yes.
What's that mean?
That means normal appearing facial. Yeah, normocephalic means it developmentally appears within normal limits.
Okay. And a normal head size too, right?
Correct. I didn't measure it, but yes.
Okay. But it appeared that way.
Correct.
There were no abnormalities in that to his head other than what you talked about.
To his head.
Yeah. Okay. He looked at his right ear. You talk about the tympanic membrane perforation, or you were looking for that. Is that inside the ear?
Correct.
Okay, so there was no damage to either ear, other than the cut along it.
No, I just mentioned the laceration.
Yeah, okay. You mentioned with the nose, it was not no congestion or what's called Reiner which is basically running nose.
At that time.
Okay. His cardiovascular rate and rhythm was normal.
When I examined him, yes.
His breathing was normal. No wheeze.
Yes.
You note in the musculoskeletal cervical back spasms and tenderness present, period. No deformity or bone tenderness, period. Pain with movement present. What is, we talked about the tenderness. What are spasms? Is that?
That's palpable when you actually feel someone's neck
Tighten up.
and you can feel it tighten up.
Okay. You notice a 3 millimeter abrasion to the tip of his nose.
Correct.
A 1.3 centimeter laceration to the helix of his right ear.
Yes.
That's the outermost, most prominent rolled edge of the ear.
Yes, sir.
Is that why it required 4 stitches rather than fewer because of where it was sitting?
That would be about the number of stitches it would take if it was really anywhere on the body.
Okay.
Yeah.
All right. Then you go down to neurological on page 3 of 6. We were just talking about 3 of 6 and Exhibit B. Neurological, no focal deficit present. What is focal deficit?
Yeah, I put no focal deficits.
Now, what does focal deficits mean?
Focal deficit would be like unilateral weakness of a leg, an arm.
It's also problems with nerve function
Correct.
that might affect a specific part of the body.
Correct.
Such as the brain. Nervous system, brain. Right.
I'm not following your
You
question.
need to ask a question. You just were saying words. Ask a question.
Focal deficits are problems with nerve function that affect specific parts of the body, correct?
Correct.
All right. They're caused by damage and disruption to a particular area of the nervous system, such as the brain, spinal cord, or single nerve, correct?
Correct.
Symptoms include loss of movement or strength.
Your Honor, I'm going to object. If this wasn't present, why are we going through this?
Well, I think you need to wrap up this point. I think you're belaboring a little bit. I'll let you ask that question. Go ahead and answer.
If he had it, or symptoms of focal deficit would be, could be speech problems, right?
Could be.
All right. And you talk about mental state on page 3 of 6, mood and effect, mood normal, right?
Yes.
All right. You also note he is alert and oriented to person, place, and time, right?
Yes.
And then the last thing, you said cranial nerves, no cranial nerve deficit.
That would be no focal deficit, sir.
That's the same thing as what we talked about.
Cranial nerves are different nerves that control different movements on our body, but that would be no focal deficit.
Cranial nerves, are cranial nerves 12 nerves that are connected with the brain?
There are.
Okay. You did some testing. There was testing done. You reviewed the x-rays and you agreed with the reports of the neurologist?
Yes, sir.
Okay. On page 4 of 6, the x-rays, you already, the first thing is a CT head without contrast. Has a CAT scan
Yes.
of the head. Your impression was no acute intracranial abnormality, right?
Yes, sir.
There was another test done, CT facial. That's where the fracture of the tip of the left nasal bone was.
Correct.
Okay. And I think I already asked you, non-displaced means it didn't come through the skin or it's not out of place. Right?
Yes, sir.
So it's just a crack, a little crack.
Yes, sir.
Okay. With that, there was no treatment needed, right? He just found out it was cracked and he didn't need to put a splint
If
on it.
non-displaced, typically not.
Okay. In this case, it wasn't. That you did.
Not in the emergency department.
Okay.
I don't have any other knowledge of aftercare.
But I mean, did you finish? Did you finish your answer?
I did.
Okay. I mean, you didn't say, hey, you need to go get your nose looked at again or anything like that.
I typically discuss with anyone who has lacerations, fractures, to follow up, especially in this case if they feel warranted within your nose and throat for fractures.
Okay.
Yeah, but typically there's no treatment rendered for that.
Okay, understood. And then with regard to the stitches, that just stays in and they get taken out?
Get removed in 10 to 14 days.
10 to 14 days. Okay. There was a CT spine cervical, that's the neck, right?
Yes.
The impression was no evidence of acute traumatic injury, right?
No acute traumatic fracture, I believe.
No.
is what it said.
Well, why don't you read
Yes.
the impression?
Yes, it is. First impression, no evidence of acute traumatic injury of the cervical spine.
Okay. Let's go down to the next finding on that impression. Can you read that in paragraph or in the second impression?
Number 2,
Yes.
multi-level degenerative spondylosis, more prominent at C3, 4, 4, 5, 5, 6, and C6, 7, resulting in moderate to severe spinal canal and neural foraminal narrowing.
Those aren't new injuries, right?
No, they're degenerative.
All right. Page 5 and 6, I'll talk about a closed fracture of the nasal bone. That's similar to what we would see, and you've probably seen sports injuries or where people get elbowed or something, right? Right.
Yes.
Okay. The symptoms could include, or let me strike that. You didn't note any swelling or bruising.
Just to the nose that I've already mentioned. Typically, there's some swelling associated with
I know
fractures.
typically, but you didn't note it on this particular incident, right?
I did not.
Okay. We talked about how you can treat that, obviously. Well, we've talked about that. And then I didn't ask you this. How long does it take for that fracture to heal? A few weeks? Or?
It's variable from person to person, but typically anywhere from 2 to 3 months. Most people will be 2 months or less.
Okay. But that's just the fracture itself, to grow
Correct.
back together. Okay. When you discharged him from your care, you didn't prescribe any type of protection device for his head, like a helmet or?
No, sir.
Okay. And you didn't even recommend that he use ice, right?
Can you repeat that?
Yeah. You didn't even recommend that he use ice.
I think I discussed that with him as I was actually suturing his ear. I discussed many things as far as treatment at that time.
You mentioned earlier, and it's in your notes, acute post-traumatic headache, not intractable. A post-traumatic headache is a headache, or I'm going to ask you this, is a post-traumatic headache a headache that develops after a head injury and is not severe enough to be considered intractable, meaning unmanageable?
Correct.
The symptoms of that would be headaches that may be throbbing, pulsating, or dull.
People describe headaches in different ways.
Okay. Other symptoms may include nausea.
It can.
Okay. Dizziness.
It can, but
Your treatment, Mr. Flygore, was, if I'm correct, and please take a look at the discharge summary there, which is was attached to the other report. But it appears that he was given over-the-counter pain relievers, ibuprofen or something to that effect, right?
yes.
Okay. The medicines that you prescribed for him were, let's see, Toradol,
Yes, sir.
and that's for short-term pain?
It is. It's a non-steroidal anti-inflammatory medicine.
Okay. Are there side effects to Toradol?
Potentially, there's side effects to any medication.
Headaches?
I haven't seen that clinically, but
You read the warnings when you prescribe?
sure, each medication has about 20 or 30,
Right.
warnings.
Do you have any reason to disagree that headaches, dizziness, or side effect?
The reason I give him the Toradol, he was complaining of a headache to begin with, so it was for pain relief, sir.
But the medicine itself, a side effect.
I'm going to object. You said no.
Yeah, I'm going to sustain that.
You prescribed cephalexin.
I did.
That's a antibiotic.
Yes, sir.
That was to the ear
Correct, and the nose abrasion.
and the nose. Okay. You prescribed ibuprofen, Robaxin, which is a topical, is that right? Or what's Robaxin?
Robaxin is a type of muscle relaxer.
Okay. Does that have any known side effects?
Certainly it can cause, again, medications come with a whole list of side effects. I think the most common for that would be feeling off balance or, tired.
Headaches?
Objection.
Sustained.
May we approach them?
Sure. You may continue.
All right. We talked about the treatment was over the counter, the prescriptions. You didn't prescribe any physical therapy, right?
I did not.
And other than the follow-up with his, you told him to follow up and with his family doctor after that?
I did
If
request him to follow up with his PCP.
I got you. And then also you recommended he follow up for a suture removal in 10 to 14 days.
Yes, sir.
Can somebody that had been diagnosed with Lyme disease suffer from headaches?
I'm going to object.
Sustained.
Did you do a Glasgow coma score?
I did.
And it was what, 15?
15.
And,
Normal.
Tell us what that means. 15 out of what?
Out of 15. That's
13
normal.
to 15 is a mild injury?
15 is considered normal.
Yeah. That's the least of the injuries.
Correct.
Okay. That's all I have.
Redirect.
Start kind of where Mr. Arnold mentioned that this nose fracture is something that you commonly see from a sports injury, somebody getting elbowed. Do you remember him asking that?
Yeah, commonly basketball, soccer, martial arts.
Is it also something that you commonly see when someone gets punched in the face?
Yes.
And you mentioned it takes 2 to 3 months for that fracture to heal.
It's variable, but about 2 to 3 months.
And does it hurt?
It does.
And it's been discussed that it didn't come through the skin, which would make it a displaced fracture, correct?
Yeah, you would see it on the CT scan as a displaced fracture.
So is a fractured bone that doesn't come through the skin still painful?
It is.
And Mr. Arnold went through all these notes about things that weren't present. So no congestion is mentioned in your notes. So would that mean he didn't have a cold?
Can you repeat that?
Does that mean he didn't have a cold when he came in?
Correct.
Okay. If a patient comes in for a shark bite on their leg, but nothing to their head, would their head show normal on your notes?
Yes.
He mentioned that he was not in acute distress on page 206. What is acute distress?
Acute distress, to me, is a red flag. If someone comes in and you can visibly tell they're having difficulty breathing or holding their chest and appear to be in severe pain.
So we need to get to work to save this man's life.
Correct.
Okay. You noted neck tenderness. Do you consider that to be pain?
I do.
What was the muscle relaxer that you prescribed?
Robaxin,
And what was that prescribed for? What was that prescribed to treat?
the spasms in the neck.
Okay. So he was suffering from spasms from the sprain in his neck?
Correct.
Mr. Arnold mentioned physical therapy. Is there physical therapy for a nose fracture?
There is, not to my knowledge.
What about the laceration to the ear that requires stitches to close up?
Not to my knowledge.
I have no further questions.
All right, you're excused. Thank you. Next witness.
Gandhi Palmer.
Were you sworn in the clerk's office? All right, if you have a cell phone, make sure it's off. Also, this is being broadcast on YouTube, and photos could be downloaded from that. Do you have any objection to that? All right, thank you. Just have a seat over here. And, yeah. That's the microphone there with that red light, so try to speak into that. Keep your voice up, please.
Okay.
May I inquire?
Thank you. Please state your name for the record.
It's Donita Palmer.
And are you currently employed?
Yes.
Before we go any further, have you watched any of the trial on YouTube this morning?
No, ma'am.
And you mentioned that, are you currently employed?
Yes.
And where are you employed?
At the Greenfield VFW.
And were you employed there in February of 2025?
Yes, ma'am.
Were you working on February 14th of 2025?
Yes.
Are you familiar with Shane and Jennifer Flagger?
Yes.
And do you recall Shane and Jennifer being at the VFW on February 14th of 25?
Yes.
Are you familiar with Timothy Campbell?
Yes.
And how are you familiar with him?
I actually went to, well, he's older than me. I knew him through school.
And do you see him in the courtroom today?
Yes.
Can you please point him out for the court?
He's right there.
Please let the record reflect the witnesses identify the defendant.
Sword.
And did you see the defendant at the VFW on February 14th of 25?
Yes.
And did you see him leave the VFW on the night of February 14th of 25?
Yes.
And when he left, where were you?
I was outside.
And what were you doing outside?
I was out. I was on a smoke break.
I'm
So
sorry,
I was
ma'am.
outside.
I didn't.
Yeah, I'm having trouble. You need to lean up and
I'm
speak
sorry.
a little louder, please.
I was actually outside on a smoke break.
Okay.
So
And when you saw the defendant leaving, did he say anything to you?
when he came out, I said, "Hey, Campbell, what's wrong?" And he's like, "Oh, I just beat the fuck out of somebody." And
Wait a minute.
You're gonna-
Truck came by.
I'm like, I don't-
Hold on. Okay, start your answer then, please.
okay.
Let me ask the question. Okay. When you saw him leaving, did he say anything to you?
I had asked him, what's wrong? And he said that he had just beat the fuck out of someone.
What did you see him do next?
He walked across the alley and then came back towards the V and then went in between Subway and the V, and then I don't know where he went from there.
I have no further questions.
Cross?
If I understood you right, you didn't see the incident.
No, I did not, sir.
Okay. All right, thank you.
Redirect?
None.
All right, you may step down. Thank you. Next witness?
Rhonda Matrasha.
Oh, that was a supplement.
Where's what I gave you this morning?
Well, were you sworn in the clerk's office?
Yes.
All right. This is being broadcast on YouTube, and pictures can be downloaded from that. Do you have an objection to that? And if you have a cell phone, make sure it's off. All right, good. Seat over here behind that microphone. And if you would, kind of lean forward and speak into the microphone when you're answering questions.
Okay, thank you.
All right, you may. All right.
Thank you. Please state your name for the record.
Rhonda C. Matrasha,
And can you spell your last name for us?
Matracia.
Have you watched any of this trial on YouTube?
No.
Are you currently employed?
Yes.
And where are you employed?
The VFW Post 4736 in Greenfield?
And is that where you were employed in February of 25?
Yes.
Were you working at the VFW in Greenfield on February 14th of 25?
Yes.
Do you know Tim Campbell?
Yes.
And how do you know Tim?
I've known Tim since we were kids.
Do you see Tim in the courtroom today?
Yes, I do.
Can you point him out for the court?
He's right there.
Please let the record reflect the witnesses identify the defendant.
Sure.
Did you see the defendant come into the VFW on February 14th of 25?
Yes.
Is he a member of VFW?
No.
And what did you see him do when he came into the VFW?
When he came in, he went up to the bar, ordered a drink. I hollered at him. He stopped and spoke with me. And after that, I kind of lost track of him in the crowd.
What was the next thing that you saw? The next thing that caught your attention?
There was a commotion. I was at one end of the bar. The commotion was at the back end of the bar. The band stopped playing. The lights come on. I went back to see what happened and seen Mr. Flagger laying on the floor.
Does the VFW maintain a surveillance system?
Yes, we do.
And are you able to extract video from the surveillance system?
Yes, we are.
And were you requested to do this for the night of February 14th, 25?
Yes, I was.
Who asked you to extract the video from the
The
surveillance?
Greenfield police officer.
I'm going to hand you what's previously been marked as State's Exhibit 1 for identification purposes. Do you recognize this?
Yes.
Is this the copy of the video from the surveillance system at the VFW on February 14th of 25?
It is not a copy from the surveillance system. It is a copy from the policeman's phone.
Okay. Have you reviewed this?
Not that actual copy, but I did review it on the camera system at the club.
Okay. So is the copy that the policeman took a true and accurate copy
Yes.
of what was on the surveillance system?
Yes.
At this time, I would move to admit and publish State's Exhibit 1 for identification purposes.
Strong?
No.
That's admitted. You may publish it.
Now, can you identify the people in the video?
Yes, most of them, yes.
Okay.
He's probably going to need to move out of the way.
Baby. Were you able to see Shane Flagger in the video?
Yes, he was sitting against the wall right there. There's a chalkboard hanging on the wall. He was sitting right below it.
In this area?
Yes,
And were you able to identify the defendant in the video?
yes.
And where was he?
He was standing facing that way in the bar towards the front door. Standing there, he looked like he was having a conversation with Mr. Flagger.
Okay, let's back it up just a bit, all the way, actually. So, pause.
So
This person?
yes, that person right there is Tim Campbell,
And then here?
as Shane.
Okay. Now, after that happened, what did you do?
Once the lights come on and I was aware of the situation in the bar, I walked back there to see what was going on. Shane was laying on the floor. His wife was hovering over him. He was completely unconscious. I told everybody else to back away. I asked her if they needed an ambulance or the police department called. That way I could take care of that.
Was Shane bloody when you saw him?
Yes.
Now, the video is a little bit dark. Why is that?
It was at nighttime. We had a band in there and the lights were lowered.
And no further questions.
Ross?
Yes, should I move this back or? So at the time of that incident, the band was playing
Yes.
and the place is packed,
Yes.
it's very loud.
Yes.
Okay. And you didn't hear anything that happened over there?
No. I was not actually ever sitting over in that area either.
Okay. Who's the head of that VFW?
At that time, Mark Little was the commander.
Who is the manager?
Shane Flagger is the commander now.
So who's your boss?
My boss is a house committee.
Is what?
It's a house committee.
Okay.
It's made up a group of the veteran officers.
All right. He's the head guy.
Mm-hmm.
All right. Did you, if I understand it right, because I have a friend, if somebody's a member of the VFW, they can invite you to contact.
Yes.
And that happens when you have bands a lot.
Yes. We actually had an open to the public night that night.
Okay. All right. So it wasn't surprising to see Tim there, right?
No.
Okay. And in fact, if I understand it, don't people have to knock on the door to get in and in the door?
Yes.
I didn't see him go to the ground, but you said when you walked around there, his wife was over him on the ground?
Yes.
So you don't know if he fell out of the chair or if they helped him down?
No.
Okay. Do you know a Dorothy Leach?
Yes.
Who is that?
She is a bartender at the club.
And where is she in that picture? She behind the bar?
Yes, she's standing right there by, it's an ice machine is what it is.
The farthest person? in the
Yes.
room? So she's got her back to the... Right.
As far as I can tell, yes.
Okay. Do you, Chuck Bender, do you know him?
Yes.
Where's he?
He was standing at the end of the bar where he always stands.
Which end?
See where the play symbol is? He would have been right there at that end of the bar, facing that way, facing towards the front door. So he would have seen everything.
So he was up here on this end?
Yes.
Oh, okay. And does Dorothy or Chuck work there?
Dorothy does. She is a bartender. Chuck was hired as a maintenance lawnmower person for the club. Yes.
The band?
Yes.
Huh. And do you know Angela Hurlis?
Yes, I do.
Can you tell us where she is?
It's a little distant from here, but I think she's at the bar right there beside Shane on the other side of the table. It's kind of hard to see from here.
Is she facing the bar?
She's facing Shane, I believe.
And then Brandy T, you know her?
Yes. See where Tim's standing? Brandy was sitting right on the other side of that, facing the front door.
So the one with the dark, what appears to be a jacket or something,
Yes,
dark hair?
yes.
And then Bridget Davis?
I do know her, but I do not see her there.
Okay. And then, I'm not sure if it was this, but John Wilson, you know?
John Wilson, he is, I'm sure he was there. I don't know where he was at that moment. No.
When we saw the lights come on, is that when the band started?
Yes,
So it was loud up until that point?
yes.
Okay. That's all I know.
Redirector.
Just a few questions. Are you testifying here today because? Let me ask. Can Shane fire you as the director or commander?
No.
He doesn't have the authority to
No.
fire you. And when was he made the commander?
He wasn't made the commander till July 1st of 2025.
And so, would you have any reason to change your testimony because of his position?
No,
When you got to Shane, was Shane unconscious?
yes.
And no further questions.
All right, you may step down. Thank you. Next witness.
Dorothy Leaf.
Were you sworn in the clerk's office? Were you sworn in the clerk's office? All right. If you have a cell phone, make sure it's off. We're broadcasting this on YouTube, and pictures can be downloaded. Do you have any objection to that? All right, just have a seat over there then. All right, you may. Oh, that is the microphone, so make sure you speak loudly and into that, please.
Okay.
All right. You may inquire.
Please state your name for the record.
Dorothy Leith.
And have you watched any of this trial on YouTube this morning?
No.
Are you currently employed?
Yes.
Where are you employed?
Greenfield VFW.
And were you employed there in February of 25?
Yes.
Were you bartending on February 14th of 25?
Yes.
Are you familiar with Shane and Jennifer Flieger?
Yes.
And did you see Shane and Jennifer in the VFW that evening?
Yes.
And can you tell us where was Shane sitting?
At the table across from me, the first one right in the corner.
Did you see Tim Campbell in the VFW that evening?
Yes.
And did you see Tim Campbell in the courtroom today?
Yes.
Can you point him out for the court, please?
In the brown.
Please let the record reflect the witnesses identified the defendant.
Sworn.
And when the defendant came into the VFW, was Shane sitting at the table?
Yes.
The wall behind where he was sitting, what kind of wall is that?
It's just the corner.
Is it a concrete wall, a brick wall?
It's panel, I think.
And what did the defendant do when he came in?
Well, he came in, he ordered a beer and mingled, and then he ended up over there in the corner, and he was pointing at him. I couldn't hear what he said, but
Okay, when you say he, who is he?
Tim Campbell
Was pointing
at Shane Flagger.
okay.
While he was sitting there, he had his finger pointing at him, and I don't know what he said, and
And then what did you see?
I saw him hit him 2 times. That's what I seen. And then
You saw him.
Tim hit Shane Flagger.
Okay. Prior to the defendant hitting Shane, did you see Shane do anything?
No,
Did he move out of the chair at all?
no,
Did you hear Shane say anything to the defendant?
no.
I have no further questions.
Ross.
You were behind the bar, right?
Correct.
And you were facing away from Clyde.
Facing away from him?
Yeah.
No.
Okay. So if the video shows your back to it, what would be more accurate, the video or your testimony?
The video shows my back to all of that.
You're doing something. Can you cue it up for me, please? At the beginning, just at the beginning. While we're waiting on that, I'll ask you another question. Shane was sitting at a high top.
Yes,
And so it's like a higher chair.
The bar stools are all the same.
Okay. There's a bar stool, not down on like a regular table.
No.
Is that you over on the right in the white? And the blonde hair? At the sink or something?
I don't have my glasses on.
Can you get closer?
You want to step up a little, look at it, you may.
I have some readers if that help. Is that you on the right, facing towards the sink? Yes. Okay, thank you. That's all I have here.
Redirect.
Yes. Can you push play? So, did you turn around?
Yes.
So, if you only saw him hit him 2 times, if you only saw the defendant hit him 2 times, would that be because you weren't watching?
I was busy.
Answer my question.
Yes.
Would that be because you weren't watching if he hit him more than 2 times?
Correct.
No further questions.
All right, you may step down. Thank you. Next witness.
Angie Hurlis.
You should be after her. I don't know.
Were you sworn in the clerk's office?
Yes, I was.
All right. If you have a cell phone, make sure it's off. And this is being streamed on LiveTube, and there could be photographs downloaded off that. Do you have an objection to that? All right. Just have a seat over here, please, then. That is the microphone on that little board there with the red light, so make sure you lean toward it and speak up when you're answering questions.
Okay.
You may inquire.
Thank you. Please state your name for the record.
Angela Hurlis.
And have you watched any of the trial on YouTube this morning?
No.
Are you familiar with the VFW in Greenfield?
Yes.
And do you go to the VFW?
Yes, I do.
Okay. Do you know a Shane Flagger?
Yes.
Do you know Tim Campbell?
Yes.
And do you see Tim Campbell in the courtroom here today?
Yes, I do.
Can you point him out for the court, please?
Over there.
Please let the record reflect the witnesses identified the defendant.
It's ordered.
Going back to February 14th of 25, were you at the VFW that evening?
Yes, I was.
And where were you sitting at the VFW or standing?
I was sitting up there where the bar was.
Did you see Shane Flagger at the VFW that evening?
Yes, I did.
And where is he sitting?
He was sitting behind me up against a wall in the chair in a corner.
Did you see the defendant come into the VFW that evening?
Yes.
And what did you next see? Just tell us in your notes.
He turned around, and as I turned around,
Instead of saying, I'm just going to interrupt you, I'm sorry.
okay.
Instead of saying he and him, can you use their names so we know who you're talking about?
Yeah, Shane was sitting in the corner in the chair, and Tim came in the door and turned around and ran toward Shane and hit him.
Do you know how many times?
No. I just seen him hit him that one time.
And did Shane fall out of the chair?
Yeah, he went on the floor.
Did you see Shane throw a punch at the defendant?
No, I did not.
Did you, did the defendant stop punching him on his own, or did people pull him off?
I seen it one time, and that was it.
Once they got the defendant off of Shane, were you able to see Shane?
Yeah, he had blood all over him.
Was he unconscious when you first saw him?
He was laying on the floor.
Did you hear the defendant say anything to Shane?
No.
I have no further questions.
Cross.
Just real quick. Did you hear Mr. Flagger say anything to Shane?
No, I did not.
Okay. And Your testimony is that Tim came in, you said the door is at the front door?
Yeah.
And went straight to him and punched him?
He stood there for a few minutes and then went over there to Shane and hit him.
You went up to the bar to get a drink, right?
Yes,
And Mr. Flyer was drinking as well, right?
correct.
Okay, that's all.
Redirect?
No further questions.
Okay, you may step down and leave. Thank you. Next witness.
Chuck Bender.
Were you sworn in the clerk's office?
Yes, I was.
All right, if you have a cell phone, make sure it's off. Okay. We're streaming this on YouTube, and photos could be downloaded from that. Do you have any objection to that? All right, just have a seat right over there in the witness chair, please. That's the microphone there with the red light, so make sure you lean toward it and speak up when you're answering questions. You may inquire.
Thank you. Please state your name for the record.
Charles Bender?
You go by Chuck.
Yes.
Okay. Have you seen any of this trial on YouTube this morning?
No, I have not.
Okay. Are you familiar with the VFW in Greenfield?
Yes, I am.
Do you work there?
Yes.
Okay. Are you also a member?
Yes, I am.
Did you happen to be at the VFW on February 14th, 2025?
Yes, I was.
Do you remember where you were at in the bar that night?
Yes, I do. I was standing at the end of the bar.
Okay. Do you know Shane Flyer?
Yes, I do.
Do you know Tim Campbell?
I know of him.
Would you know him to see, if you saw him, you would recognize him?
Yes, I would.
Okay. Did you see Shane at the VFW on February 14th of 25?
Yes.
And did you see the defendant at the VFW on February 14th of 25?
Yes, I did.
And what did you see, if anything, that took place that night?
Well, I saw Tim walk in. It looked like him and Shane was having a conversation. And then Tim started swinging
Started swinging at who?
at Shane Flagger.
Did you see Shane swing at the defendant at all?
No, I did not.
Did you see Shane move toward the defendant at all?
No, he didn't.
When Tim hit Shane, did it knock Shane out of his chair?
Yes, it did.
You said that you are employed at the VFW.
Yes, I am.
With Shane being the commander there, does he have the authority to fire you?
I'm not sure if he does or not.
Well, if you don't know, is that impacting your testimony here at all?
No, it is not.
Okay. And the Tim that you saw hit Shane that night at the VFW, do you see him in the courtroom today?
Yes, he's sitting over there.
Please let the record reflect the witnesses identified the defendant.
Order.
No further questions.
Cross.
Just briefly, Mr. Bender, I think somebody testified, but from your point of view, you were at the end of the bar.
Yes, I was.
So what your point of view would have been to Tim's back.
Yes, it was.
And you did not hear either one of them say anything to the other?
No, I did not.
Okay, that's all.
All right, you may step down. All right, it's 11:57, so we're going to break for lunch. I'll ask for you to be back to the jury room by 1 o'clock if possible, 1:05, that might be with traffic, I don't know, but try to make it back by then. During the break, remember all the instructions I've given you. You're not to talk to anyone that's involved in the case, any of the witnesses, or with anyone else about the matter. Don't discuss it among yourselves. Don't try to find any information on social media or internet about any of the matters that have been discussed here today. And like I said, return back to the jury room at 1 o'clock. Thank you.
Please rise.
right, we're back on record. Case of State of Ohio versus Timothy Campbell. Recess for lunch. Back assembled here. The next witness for the state.
Shane Flagger.
Were you sworn in the clerk's office?
Yes, sir.
This is being streamed on YouTube, and photos could be downloaded from that. Do you have any objection to that?
No, Your Honor.
All right. If you would have a seat over here, please. And if you have a cell phone, make sure it's off. And if you would pull that, that's a microphone for red. Pull it far left as it'll go, and lean into that and speak, please, when you answer questions.
Yes, Your Honor.
May inquire.
Thank you. Please state your name for the record.
Shane Flagger,
And can you spell your last name for us?
F-L-I-G-O-R.
Have you watched any of this trial on YouTube this morning?
Not this morning, no.
And do you live in Greenfield?
I do.
Are you employed?
I work for McLean High School. I'm a substitute teacher and an assistant instructor mentor for the McLean Cadet Corps.
What's the Cadet Corps?
The Cadet Corps is very similar to an Army or an Air Force JROTC program.
So you previously served in the military?
I did. I served 23 years in the active duty Army, and I retired in 2021.
Were you deployed?
I deployed 3 times to Iraq and 1 time to Bosnia.
Are you married?
I am married to my wife, Jennifer. We just celebrated our 18th year anniversary.
Do you know Tim Campbell?
Yes, I know who Tim Campbell is, yes.
And how do you know him?
I saw him at the high school where he was also working as a substitute teacher, and then we had a few brief interactions outside of the school.
And how long have you known him?
I think I found out who Tim Campbell was probably in 2023 or 2024, again, where we would pass each other in the hallways.
Do you see him in the courtroom today?
Yes, I do. He's over at the defense table.
Please let the record reflect the witnesses identify the defendant.
Sword.
Now, at some point in late 2024 or early 2025, did you and the defendant have an interaction or a disagreement?
Tim Campbell and I have had a few interactions, again, outside of the school. We've never talked to each other inside of the school. The first time I had gone to go see a band at Catch 22 there in Greenfield. I was back up against the back wall. Tim Campbell came up to me. He said, I know you. You work at school. I said, yes. And he said, you need to fucking lighten up.
Objection, Your Honor.
Objection over.
You continue.
He said, you need to fucking lighten up. Nobody at the school likes you. The students don't respect you, and they make fun of the way you dress. The gentleman next to me said, what was that about? And I said, I don't know. And I turned around and I left. The second interaction, my wife and I had just got done with the Cadet Corps event. We decided to go to the VFW. I was in my military uniform. He came in, looked at his buddy and said, look at this dude. Why does he think he's better than all of us?
Objection, Your Honor.
Overruled.
I said, I was kind of just taken back. He said, look at what he's wearing. Somebody said, did you know that's his military uniform? And he said, that's fucking gay. And I looked at my wife and said, let's go. The third interaction, we had gone out with some friends to dinner. Tim came over to our table. He asked the ladies that were with us, my wife and 2 other ladies, what they were doing with me. My wife said, I'm his wife. And he said, I always thought he was a fucking faggot. And we hadn't even ordered dinner yet. And I said, come on, ladies, let's just go. And we left.
Every single time you left?
Yes,
Now, I want to talk about February the 14th of 25. Do you recall the events of that evening?
I do.
And where were you at?
So my wife and I had left a basketball game. My wife was taking pictures. She's a photographer. I was working with the Cadet Corps. We decided to go to the VFW for a quick Valentine's date. There was a band there. We had just walked in. We had each ordered a drink. I sat down at a table at the back of the bar. My wife went to the restroom. I saw Tim Campbell walk by, and then a brief moment later, I heard him yell my name. Without leaving the chair, I turned back around towards him, and he said, "I want to talk to you about the time I called you a faggot." I said, "Tim, now's not the time or the place to discuss this. If you want to talk about it later, we can definitely do that. But please, just go." He leaned in close to me and said, "If I slam your head through this fucking wall, I'll bet you'll fucking talk to me then." I said, "Tim, no." That's when Tim hit me and I lost consciousness.
I'm going to back up just a little bit. Was Jennifer at the table with you when this happened?
No, she was at the restroom.
Did you have a drink?
I had my drink in my hand and her drink in my other hand.
So you were holding your drink and her drink at the table?
Yes.
When he approached you and asked to talk to you or said he wanted to talk to you, did you at any point threaten him in any way?
Absolutely not.
Did you move out of the chair?
No.
When he hit you, did you lose consciousness?
Yes.
What is the next thing that you remember?
The next thing I remember is I heard my wife. I couldn't see anything. Everything was still black, but I heard my wife saying, "Shane, wake up. Shane, wake up. Shane, please wake up." I began to hear other voices saying, "Come on, Shane, what's going on? What happened? What's going on?" When I was able to open my eyes, I was sitting on the floor. I could taste blood in my mouth. Couldn't see really who was around me. I couldn't even make out my wife. I sat there for I don't know exactly how long. And finally I said, "Please get me up, get me up, get me out of this area," because we were still in the bar area. They helped me get out to the back room where I sat down for a little while. They brought me a towel and they brought me some ice. And then I was finally able to go back into the restroom, and I went and saw the blood on my face and I began to wipe it off. And that's when my wife and I decided we were going to go to the police station and then go to the hospital.
So you did go to the hospital that evening?
Yes, ma'am.
And what were you treated for there?
I had 5 stitches in my right ear, a broken nose, and a sprained neck.
Did you seek further medical treatment after that?
Yes, it was a few days later. I was having a lot of headaches, trouble seeing, very nauseated, was sleeping a lot. So I went to the VA Medical Center, and there I was diagnosed with a concussion.
Objection.
Rule.
Have you suffered any long-term effects from this?
So still to this day.
I'm sorry, Your Honor. Objection.
I didn't hear the question. What's the question?
I asked if he had any long-term effects from this.
Overruled.
You can answer.
Still to this day, I have a lot of ringing in my right ear. My neck is still stiff. I mean, it's a lot better than it actually was. I'm having trouble sleeping, incredibly anxious. There are times that I'll be in a classroom or I'll be having a communication with somebody, and I will completely forget what we were talking about, what I was saying at that time. And it's, somebody will remind me what we're talking about, and it's like I'm completely lost. It'll take me several minutes to get everything back.
When you went to the Greenville Police Department that evening, were pictures taken of your injuries?
Yes, ma'am.
May I approach?
Yes.
Getting into you as previously been marked as State's Exhibit 2 for identification purposes. Do you recognize this?
Yes, ma'am.
What is that?
That is a picture of me at the police station, definitely showing the injuries to my nose.
And State's Exhibit 3, do you recognize this?
Again, yes, ma'am. Again, taken at the police station, showing my right ear.
And State's Exhibit 4?
Again, taken at the police station, showing an injury to my left side.
State's Exhibit 5?
Again, taken at the police station. This is my cadet corps jacket that has blood all down the front of it.
Was that what you were wearing?
Yes, ma'am.
At the bar?
Yes, ma'am.
Now, prior to arriving at the Greenville Greenfield Police Department. Prior to these pictures being taken, did you attempt to clean the blood off of your face and clothing?
Yes, ma'am.
Were further pictures taken at the Adena Hospital?
Yes, ma'am.
Getting into what's previously been marked as State's Exhibit 8 for identification purposes. Do you recognize that?
Yes, ma'am. Again, it's taken at the hospital, showing my right ear.
And State's Exhibit 9?
Yes, ma'am. Again, taken at the hospital after the stitches were put in.
And State's Exhibits 2 through 5 and 8 and 9, are these true and accurate depictions or true and accurate pictures of how your face and head looked that night?
Yes, ma'am.
Now, on the next day, on February 15th, after this attack, did you attend a cadets ball?
Yes, ma'am.
And what is that?
So the Cadet Corps Ball is an annual event. It's similar to a homecoming and a military ball combined into one. The cadets will wear their uniforms, or the ladies will wear formal dresses. It's attended by our cadets and also 2 Air Force Junior High School JROTC programs. In this event, there will be a color guard, a saber arch, and each of the cadet corps will have a king and a queen in their court that is voted on by their classmates. We have a formal dinner. The kids produce a dance that they do as a group, and then also there's dancing afterwards.
Now, why did you go to this?
So, since being a part of the Cadet Corps, the main thing that I've learned is that the cadets want from me and from all these instructors is they want us to be there for them. So the most important thing I can do when I make a commitment is to show up. Regardless of how bad I feel, or, they don't care if I'm sick or nauseated. They want me to be there, and I want to be there for them. These cadets are stepping outside of their comfort level, some of them for the first time, and it's important to me to be there for them.
While you were there, how did you feel?
I was in excruciating pain. I was a severe headache. My nose hurt, my ear hurt, and the beginning of the ball was okay because it's a relatively quiet kind of thing, but the lights were bright. When the music started, though, I had to excuse myself from the room. I spent the majority of the time either out in the hallway, in the bathroom, throwing up, or out in my car until I could get the headache to subside and I could come back into the room.
Did you stay for the whole thing?
No, we ended up leaving early.
And what time of day was this the next day? Was it at 10 in the morning?
No, this was in the evening. I believe the event started somewhere around 6 o'clock in the evening.
Now, did you also attend the ball game on February the 15th of 25?
I don't remember the ball game. I was there. When I found out, when somebody had told me that I was there, I had to ask my wife. I don't remember being there at that ball game, but yes, I was there.
I have no further questions.
Cross.
Yes, John. Were you at the Ohio Regimental Military Ball?
No, sir.
That wasn't it, on the 15th at 10 a.m.?
No, sir.
You got to shut up. Okay. What?
No, sir.
Okay, I got you. When you were at that ball, your wife or somebody took pictures of you, is that right?
Yes, sir.
I've seen them.
Okay. You don't want it? I'm going to hand you Mayor Hart's John.
You may.
I hand you what's been marked as defensive today. Those are from the ball that you were referencing.
Yes, sir.
Okay. And do you know your wife posted them on Facebook?
Yes, sir.
Okay. And do you know why she took them down the next day?
No, sir.
Did you tell her to take them down?
No, sir.
Okay. Assume that your rank is higher than Tim's in the military.
I don't know what Tim's rank is.
Okay. You're what, an E7 or what are you?
Yes, sir.
And thank you for your service, by the way.
Thank you.
I had that written, but I took the pictures first. Okay. If he were an E3, would that be lower than an E7?
Yes, sir.
Okay. The basketball game was at 1 o'clock, or do you know?
I don't remember, sir.
Okay. You mentioned a couple things. You said you had ringing in your ears, right?
Yes, sir.
Prior to February 14th, you were diagnosed with tinnitus, or
Yes, sir.
say?
Yes, sir.
Okay. That's a ringing in the ears.
Yes, sir.
Okay. You were also, on that day, you were taking medications for anxiety.
Yes, sir.
Okay. Do you know any of the side effects of that medicine?
Not off the top of my head, sir.
Okay. Now, you mentioned 3 incidents. The first one, I didn't catch where you said you were.
It was a catch-22.
Catch?
Yes, sir.
Okay. Is that a bar?
Yes, sir.
And did you say you were in uniform?
No, sir.
Oh, okay. Were any of these incidents at Furman?
Yes, sir.
Okay, is that the second one?
That was the third one.
The third one?
Yes, sir.
So the fourth one is the punch?
Yes, sir.
Oh, I got you. Okay. And the one at Furman's, did you accuse him of looking at your wife?
No, sir.
Okay. When you went to the basketball, well, you don't remember anything from the basketball?
No, I do not, sir.
Did I hear you say that the whole encounter you were holding 2 glasses of drinks?
I was holding a can in a plastic cup.
Okay. You didn't have them just sitting on the table?
No, sir.
Okay. And are you an instructor on self-defense?
No, sir.
You don't instruct anybody or any academies on self-defense?
No, I do not, sir.
Hand-to-hand combat?
No, sir.
Okay. When you all went to the police station that night, it looks like you gave a statement around, I don't know, 25. Is that about right?
Around 25. I don't understand.
2025 time.
Yeah.
That sounds
I believe
about right.
that's
Yes,
the year.
Oh, my bad. Yeah, that's the year. What time did you go to the police station?
This was immediately after the incident. I don't recall exactly what time it was, sir.
And you drove there?
My wife drove, sir.
Okay. And there was no emergency vehicles there to transport you anywhere?
Officer Smith had asked if we wanted a emergency vehicle. Greenfield ER is about 2 blocks away from the police station, so my wife decided it would just be as fast for us to drive.
No, I mean from the VFW.
No, there was no.
All right. And so did you and she walk over to the hospital or drive?
She drove.
So you went from the police station in your car over to the hospital?
Yes, sir.
All right. By the time you got to talk to the doctor, were you able to communicate your symptoms?
Yes, sir.
Okay. So by then, the confusion was clear enough to tell a doctor what was wrong with you?
Yes, I mean, my injuries were very clear, so I was able to say, this hurts and this hurts.
Okay. And you told him everything at that time that you were feeling?
That I was feeling at that time, yes.
All right. Okay. That's all I have.
Redirect.
Defense counsel mentioned anxiety meds. Is that from PTSD?
Yes, ma'am.
Was that from your deployments?
Yes, ma'am.
Has that been exacerbated by this event?
Absolutely.
Go ahead. I'm sorry.
Nightmares are one of the biggest things that I deal with my PTSD, and now the nightmares that I had before are now replaced by I can't see, and I hear my wife screaming, "Shane, wake up! Shane, wake up!" And then I hear my kids yelling, "Shane, or Daddy, help me! Daddy, help me! Daddy, help me!"
So the nightmares and things are something that was from PTSD, but now they've changed and
They've changed.
increased.
Yes.
No further
And
questions.
I'm still seeking counseling.
No further questions.
All right, you may step down. Next witness.
Jennifer Flyer.
Were you sworn in the clerk's office?
Yeah.
All right. If you have the phone, turn it off. We are streaming this on YouTube, and pictures can be downloaded from that. Do you have any objection to that? All right. Just have a seat over there, please. That's the microphone there to your right with the red light. If you would slide that on the board as far left as it will go.
On here.
Yes. And just lean forward and speak in that when you're answering questions, please.
Yes, sir.
All right, you may inquire.
Please state your name for the record.
Jennifer Flagger,
Can you spell your last name for us?
Fligor.
And have you watched any of this trial on YouTube today?
No, ma'am.
Are you married?
Yes, ma'am.
And what's your husband's name?
Shane Flagger.
And do you have children?
Yes, ma'am.
How many?
2.
Are you employed?
Yes, ma'am. I'm self-employed.
And did you previously serve in the military?
Yes, ma'am.
And what did you do?
I was a combat medic with 25th Infantry Division.
After that, what did you do?
I worked on ambulance services, 911 trucks in the city of South Tucson.
Do you know Tim Campbell?
Only by our previous encounters.
And how long have you known him? How long ago did these encounters start?
We've had several encounters with him variously over the years.
Do you see him in the courtroom today?
Yes, ma'am.
Can you point him out for the court, please?
Yes, ma'am. He's over there.
Please let the record reflect the witnesses identify the defendant.
Sure.
Now, prior to February 14th of 25, what sort of interactions had you had with the defendant?
We had another interaction with him. We had gone out for the evening with some friends and went to Furman's to grab something to eat. My friends, my husband and I had sat down at a table and laughing, joking, having a good night. And I remember him sitting at the bar and then coming around and making derogatory comments.
What did he say?
He looked at my husband and said, "Huh, I always pinned you for a faggot."
And what was your reaction to this?
I was extremely shocked. I had no idea who he was. He wasn't in our social circle at all. And who the heck are you? Why are you coming at us?
Was there any interaction prior to that where Shane became upset with him because he was looking at you or anything?
No, ma'am. I mean, we were sitting there, talking with just us.
And what did you, Shane, and your friends do at that point?
We decided at that point that we were going to leave, that it wasn't worth staying there. Our friend had asked him to just leave us alone, to walk away, to just go away. And we decided that we weren't going to stay there for any reason and left our
drinks, didn't even order food, and left.
Let's talk about February 14th. Do you recall the events of that evening?
Yes, ma'am.
And were you at the VFW?
Yes, ma'am.
Who were you there with?
I went there with my husband. It was Valentine's Day.
Did you see the defendant at the VFW that night?
I did not see him.
Okay. At some point, did you leave the table for a moment?
Yes, ma'am.
Where'd you go?
Shortly after we got there, I had to use the restroom, so I excused myself, handed my husband my drink, and went to the restroom.
Did something happen that caused you to panic?
I remember in the bathroom washing my hands, talking with one of the girls in there, and all of a sudden I could hear people starting to yell, "Shane's hurt, Shane's hurt."
And what did you say in response, or what did you do? Take us through what you did.
I remember the band was there because the bathroom's on the other side of the band. And I remember pushing through people to get to where I knew he was last. When I arrived to where he was completely slumped up against the wall, down. His head was crunched up against his chest. He was unconscious, and there was blood everywhere.
And was he making any kind of noise at all?
No, ma'am. I remember his hands were inverted, like almost like a seizure activity, like that you see. His eyes were rolled back.
And what did you do?
I yelled at everybody to get the hell away. I wanted to make sure that he was breathing first and foremost. Made sure he was breathing, tried to get him upright so I could clear his airway. And I was yelling at someone to call an ambulance, and everything just kind of started happening fast.
Now, and you've received training on what to do in that kind of a situation.
Yes, ma'am.
And when you got it, did Shane come to at some point?
Yes, ma'am. Sorry.
What did you do next?
After several seconds, he came to. We were able to get him sat up. And as he started to come to, there was all the commotion going on around. I was trying to get him up and out of that vicinity where that was, just away from everyone. And that was the one thing that he was saying was, "Get me out of here, get me out of here."
So did you take him back to a bathroom or close to a bathroom?
Yes, ma'am. So in the VFW, there's the main area, and then in the back, there's like where the office is. There was a table sat up there. We got him there. We started getting the blood cleaned up. Somebody got him ice. But I was just trying to get him to talk so I could make sure that he was coherent, that he was there, that...
And where did you take him next?
After he was stable enough, he said that he wanted to get out of there, and I told him that we needed to go file a police report, and we went straight to the police station.
And were you there when the pictures were taken of Shane?
Yes.
Was the blood washed off of him prior to those pictures being taken?
Yes, ma'am. I did it.
I'm sorry?
I washed it off.
Now, after the Greenfield Police Department, where did you go?
We went to the hospital.
And what happened there? What did you observe there?
They did x-rays while they were there. They took pictures. They ended up having to suture his ear.
As part of what you do for self-employment, do you take pictures?
Yes, ma'am.
The next day, did you have to go to a ball game?
Yes, ma'am.
And what time of day was this?
It was in the evening.
Did you take Shane with you to the game?
I was not comfortable leaving him home alone with our children because he was showing signs of concussion. I wanted to make sure that he was near me or at least friends of ours that knew kind of what had happened to keep an eye on him. he was not happy with that, but I needed him near me too.
So, Shane went to the game with you.
Yes, ma'am.
And what did he do most of the time he was at the game?
He was sitting over in the corner where I keep my gear. It was the safest spot for him. It's the least loud because it's the girls' basketball games, and he knew that he could leave and go down to the cadet corps area if he needed something to be a little more quiet too. And there would be somebody observing him at all times.
Did you get him earplugs? Did you have earplugs in during this game?
So we have earplugs that help us with anxiety or loud noises and everything, and I made him wear those so that at least the sound was dampened because he kept complaining about headaches and nausea. Like I said, all the signs of concussions.
Now, the next evening, did you also go to a cadet ball with Shane?
Yes.
And how was Shane when you were at the ball?
He was very much not there. I drove. I did not trust him, nor did he trust himself to drive. He was sleeping most of the way up there to the ball. The beginning of the ball is very docile. It's a lot of introduction, it's the court and everything like that, so it's very calm. He was able to sit mostly through that, and then later on, as the music and dancing started, he excused himself to do patrol. He used the excuse that he was patrolling the outer corridors where there was no music, where there was no lights, where there was no loud stuff that he could go, because he kept complaining that everything was making his stomach nauseous and the bright lights were hurting his head.
Did you guys stay for the whole thing?
No, ma'am.
I have no further questions.
Cross.
Yes. Your husband testified about some pictures that were posted on Facebook from the ball. Did you post those?
I'm not sure which picture, sir.
May I approach the witness, Your Honor?
Yes.
Can you show you what was marked?
Okay, this first picture was not the ball. This first picture is not this ball.
Which one was that?
It's previous years.
Okay.
Yes, I took those.
Yes.
When you went to the hospital, did you go into when they were taking a history? Were you in there with him?
Yes, sir.
Were you contributing to the information they were gathering, or did Shane provide on himself?
What do you mean, sir?
Did you tell them things that you observed that Shane didn't tell them, or did Shane tell them everything that was going on?
I only answered the questions the doctor asked me directly. I don't remember exactly.
What did he ask you?
I'm sorry?
What did the doctor ask you?
Ask me or ask him? I'm sorry, I'm hard of hearing, sir.
Oh, I'm sorry. Let me speak up. When you went to the emergency room, were you were with Shane when you met with the doctor?
Yes.
Barker.
Yes.
Okay. Did you contribute to the history that Dr. Barker gathered that night?
Which part exactly?
Well, you have some medical experience, right? You know what a history is.
Yes, sir.
It's how they determine what they're going to do, right?
Yes, sir.
Were you in there when they gathered that history with the doctor, and did you contribute to it?
I only answered the questions the doctor asked me.
Okay, what did he ask you?
I don't remember exactly what questions he asked me.
Did you tell him that his eyes were rolled back in his head?
I don't remember if I told the doctor that. I did tell the doctor that he was unconscious, yes.
Okay. Did you tell him that his neck was slumped over, unconscious?
I don't remember if I told the doctor that, no.
Did you delete these from Facebook?
Not to my knowledge, no.
Okay. They would still be out there?
Yes, sir. Only people that are my friends have access to my photos, sir.
Okay. That's all I have, Your Honor.
Redirect.
Only one question. So Jennifer, you did tell the doctor that Shane had lost consciousness?
I do believe so, yes, ma'am.
I have no further questions.
All right, you may step down. Thank you. Your next witness.
Brandy Tate.
Were you sworn in the clerk's office? If you have a cell phone, make sure it's off. Now, we are streaming this on YouTube, and so photos could be downloaded. And if you have an objection to that, all right, just have a seat over there. Then that's the witness chair. That is a microphone with a red light on, so try to lean forward and speak to that or answering questions. May inquire.
Thank you. Please state your name for the record.
Brandy with an I, Tate, T-A-I-T.
And have you watched any of this trial on YouTube today?
Ma'am.
And I'm going to talk to you about February 14th of 25. Do you recall that evening?
Yes, ma'am.
And where were you that evening?
At the VFW in Greenfield.
And do you recall seeing Shane and Jennifer Flagger there?
Yes, ma'am.
And do you recall seeing Tim Campbell there?
Yes, ma'am.
And do you see Tim in the courtroom today?
Yes, ma'am.
Can you point him out for the court, please?
He's over there.
Please let the record reflect the witness has identified the defendant.
Sword.
Did you see the defendant approach Shane Flagger?
Yes, ma'am.
And did you hear the defendant say anything?
I heard him say something to the effect of, I didn't say I thought you were gay, Shane, so it made me take notice of what was going on.
Did you hear Shane say anything?
I did not.
And did you see anything?
Well, I kind of had my back to them, so like I said, when he said that about being gay, I turned around to see what was going on. I turned back around, and then when I heard the commotion, I immediately turned back around, and it literally looked like Shane's head was bouncing off the wall like 3 or 4 times, and then Shane went to the ground, and he definitely looked out.
But why was it bouncing off the wall?
Because he was hitting him.
When you say he was hitting him?
The defendant was hitting him.
Was hitting Shane?
Yes.
And did Shane, did you see him fall? Did he fall out of the chair?
He did. He fell out of the chair to the floor between the table we were sitting at and kind of a half wall that's there.
And when he was on the floor, did the defendant stop on his own, or did people grab him?
No, there were several people trying to get him to stop and telling him to stop, to please.
And were you able to see if Shane had blood at all?
There was blood everywhere.
Did he lose consciousness?
It looked like it, yes.
I have no further questions.
Cross.
Just briefly, Your Honor. Ms. Tate, so you heard Tim in some context mention the word gay, or right?
Yes, sir.
Huh?
Yes, sir.
Okay, you got to speak up. And you didn't see the punches?
I did see the punches,
Or
yes.
when you turned around, you saw them?
Him punching him and Shane's head hitting the wall, yes. I've seen that.
And there was nobody between you and him?
No.
Where were you sitting?
At the table that was right there in front of where Shane was sitting at a bar stool by the wall.
So you were at the same table as Shane?
Well, he was kind of sitting behind the table on a bar stool, and some girls were sitting at the table.
So were there 2 tables, Shane's and then the other?
No. We were sitting at the table, and Shane had brought a bar stool, like, sort of to the table, but behind the table.
Oh, okay. All right. Do you work at the VFW?
I do not.
You were just there?
I was just there.
Okay. That's all I have.
Redirect.
None, Your Honor.
All right, you may step down. Thank you. Your next witness.
Bridget Davis.
Were you sworn into the clerk's office? Do you have a cell phone on you? Okay. We are streaming this on YouTube, so the pictures could be downloaded. Do you have an objection to that? Just have a seat over there in the chair. That's the microphone with the red light there, so to kind of lean forward and speak into that when you're answering questions. May inquire?
Hi, please state your name for the record.
Bridget Davis,
And can you spell your first and last name for me?
BRIDGETDAVIS.
Have you watched any of this trial on YouTube?
No.
Do you know Shane and Jennifer Flagger?
Yes.
And do you know Tim Campbell?
Yes.
And how long have you known Tim?
Probably since 2015.
Do you see him in the courtroom today?
Yes.
Can you point him out for the court, please?
He's right there.
Please let the record reflect the witnesses identify the defendant.
Juror?
And do you remember the evening of February the 14th, 2025?
Yes.
And can you tell us, let me back up. Were you at the VFW on February 14th, 2025?
Yes.
When this incident occurred, where were you at?
Outside.
Previously, had you been at Furman's with Shane and Jennifer?
It'd probably been a year before this incident here.
Okay. So you had been at Furman's with Shane and Jennifer?
Yes.
During an incident involving the defendant?
Yes.
And tell us about that.
There was no physical contact, but verbal. We were there to have a bite to eat. Tim Campbell turned and looked at me and told me that he was sorry that I had a faggot for a friend. And we got our food. We probably didn't even finish our food, and we left to keep from anything else escalating.
Who was he talking about?
Shane,
And how do you know that?
because he turned around and looked at me and Shane and Jennifer.
I have no further questions.
Ross?
I didn't hear the first question. You were at the VFW on the 14th?
I was
And where were you? I didn't.
outside.
Oh, so you didn't see.
No, I did not see.
Okay. In this incident at Furman's, you said that incident was over a year ago?
Yeah.
You weren't there at Furman's about a month or two right before Federal Valentine's Day?
No.
Late 2004, early 2005, right?
When?
Late 2024, early 2025?
No.
Okay, that's all right.
For director?
No, Your Honor.
All right, you may step down. Thank you. Next witness?
John Wilson.
Were you sworn in the clerk's office?
Yes.
Do you have a cell phone on you?
I do not.
Okay. We are streaming this on YouTube, so photos could be downloaded. Do you have any objection to that?
No.
We have a seat over there in the witness chair. That's a microphone with the red light on, so please lean forward and speak into that when you're answering questions.
Yes, sir.
Main inquiry.
Sorry. Please state your name for the record.
John Wilson?
And have you watched any of this trial on YouTube?
No,
And are you currently employed?
I am.
Where are you employed?
Greenfield McLean High School,
And what do you do there?
a military science instructor.
So were you, did you previously serve in the military?
Yes, ma'am.
What were you, what branch?
Air Force, 20 years.
Do you know Shane Flagger?
I do.
And how do you know Shane?
Initially, he worked with me and continues to work with me at McLean High School.
On February 15th of 25, did you socialize with Shane and his wife?
Yes.
And where did you see them?
We were heading to Mason, Ohio, down to the Manor House for a military ball, and him and his wife were chaperones.
Can you describe how Shane looked that evening?
Initially, I didn't notice anything in the chaos of steering 40 kids around, but later on in the evening when the music started and the lights were flickering, I could notice that he was wincing. His eyes fluttered a little bit. I tried to reposition him to where he had his back to the lights, and I noticed on several occasions he departed that area and went out into the lobby area.
So did Shane spend the whole evening out on the dance floor?
No, none on the dance floor. Instructors don't normally dance, but
like I said, he had to leave the room several times, and he did not stay for the entire ball.
I have no further questions.
Ross?
Did you say when you first encountered him at the ball, he looked normal?
I didn't notice anything abnormal.
Redirect.
What was going on when you first saw him at the ball?
I had a role. I had to introduce students, so I wasn't that close to him in the beginning because I was up in the front of the room. Then once all that was over, I came back to the table, and that's really the first time we interacted.
When you saw him, when you got close to him, did you notice things that were wrong?
He had some abrasions on his face, and it wasn't until later that I noticed that he seemed to be bothered by the lights and the sound.
No further questions.
All right, thank you. You may step down. Next witness.
Quentin Smith.
Have you been sworn in?
Yes, sir.
All right, seat there, please. All right, your main choir.
Please state your name for the record.
My name is Quentin Smith.
And are you employed?
Yes, I am.
Where are you employed?
I'm employed at the Greenfield Police Department.
And how long have you been employed at the police department?
I've been employed there for about 3 years.
And what are your job responsibilities, or what are your job duties there at the police department?
I'm to patrol the village of Greenfield and its jurisdiction, enforce traffic laws, respond to calls of service, and help maintain the Greenfield jail along with inmates.
And were you employed in that capacity on February 14th of 2025?
Yes, I was.
Do you recall Shane Flagger coming into the police department?
Yes, I do.
About what time did Shane come in?
He came in around 10 p.m. to 11 p.m.
And what did you observe about Shane's condition when he arrived?
When I observed Shane, he had blood coming out of his ear, he had abrasion on his nose. I observed blood on his jacket, blood on his pants and shoes.
And did Shane tell you what had happened to him?
Yeah, he stated to me that he was assaulted by Tim Campbell.
Did you take pictures of Shane?
Yes, I did.
May I approach?
You may.
And hand you what's previously been marked as State's Exhibit 2 for identification purposes. Do you recognize that?
Yes, I do.
And what is that?
This is a photograph I took of Shane.
And State's Exhibit 3. Do you recognize that?
Yes, I do.
And what is that?
This is a photograph of Shane's right ear, where he has, you can see a cut on his right ear.
And State's Exhibit 4.
This is a picture I took of his right side of his face, or left side of his face.
And finally, State's Exhibit 5.
This is the blood that I observed on his shirt or jacket.
And based on what Shane told you, what action did you take? What did you do next?
I then asked him if he needed a life squad. He stated he did not need one. They were just going to drive themselves after they were done talking with me. I then asked him what happened. Shane stated he was at the bar at the VFW drinking beer with his wife. And when he said Tim Campbell approached him to apologize about something that happened a few months ago, Shane stated to him, like, this is not time and place, like, just leave me alone. And at that point, Tim struck him in the face multiple times, causing him to go unconscious. He stated he couldn't remember what happened after he got hit. Then he said his wife was over top of him. She got him up, cleaned him off, and then they came to the police department.
And what did you go to the VFW that evening?
Yes, so after I got done talking with Shane, collected witness statements, and took photographs, myself and Patrolman Flora went to, because Shane's wife stated that Campbell could have possibly went to Catch 22. So we first went to Catch to see if he was there. He was not. We then went to the VFW. I spoke with the managers, asked them what happened. They explained to me. I asked if I could get a video footage of the incident. They stated they would get it to me on a hard drive, and I could get it up. I could pick it up tomorrow. Then Patrolman Floor and I then tried to locate Mr. Campbell by patrolling Greenfield for about 30 minutes. And at that point, I went back station and got started on paperwork.
Back way up, what's the address for the VFW?
The VFW's address is 214 Jefferson Street, Greenfield, Ohio.
Is that Highland County?
Yes, it is.
When you went to the VFW, you said that you requested a copy of the video from that night, correct?
Yes, I did.
Getting into what's previously been identified as State's Exhibit 1, is that the copy of the video?
Yes, it is.
And did you also review that video prior to today?
Yes, I have.
And
Yes, I do.
And do you see Tim in the courtroom today?
Yes, I do. He's at the defense table.
Please let the record reflect the witnesses identify the defendant.
So ordered.
And did you also see him in the video?
Yes, I did.
And now, at any point after this attack on February the 14th, did the defendant tell you that he was afraid of Shane Flagger?
No, he did not.
Did he tell you that Shane threatened him?
No, he did not.
Did he tell you that Shane was aggressive to him?
No, he did not.
Did you call the defendant the next day?
Yes, I did.
Did you tell him that he had a warrant?
Yes, I did.
And did he come right in and turn himself in?
I believe he turned himself in on February 19th, and he was arrested by Patrolman Neer.
So you talked to him on the 15th, and he was arrested on the 19th?
Yes.
And you stated that you patrolled looking for him for 30 minutes. Did you figure out where his address was?
Yes, we obviously ran him through leads and found out what his address was. He lives in Ross County, which is out of our jurisdiction.
And the pictures that you identified, are those true and accurate depictions of Shane's face and head as it appeared that day?
Yes, they are.
No further questions.
Cross.
On the 15th, when we talked to him, he said he wasn't going to make any statements before he talked to a lawyer, right?
Objection.
I'm going to sustain that.
What's the grounds?
Sustain that.
Okay. He didn't make any statements to you, right?
No, he did not.
Okay. You prepared an affidavit and an incident report in this matter.
Yes, I did.
And you're trained when you go through the academy to take good notes.
Yes.
And you note those facts that obviously you observed or would be important.
Yes.
You did that in this case.
Yes.
Okay. You would agree with me that there was no 911 dispatch?
I don't recall.
Well, you would recall that because you're in charge of dispatch, right?
Not at that time, no.
Not that night?
No.
So you just happened to be there when he showed up?
Yes.
Okay. But nobody called you and dispatched you to the VFW?
No.
Okay. It looked like your timing was 22:48. Does that refresh your memory about what time he was there? All right, what time the incident was?
Yes.
No, that's when he came in. I apologize.
Yes, that's when he came into the police
Okay. All
department.
right, I got you. In your affidavit, you said that Shane Flagger said he might have been knocked out, right?
Yes. Shane couldn't really say. So when Shane got hit, he said he couldn't recall exactly what happened after that incident.
My question was, you quoted, he might have been knocked out, or that he might have been knocked out.
Yes, that's what Shane advised to me.
Okay. You mentioned statements a few minutes ago. The only two that I saw were Shane Flagger and Jennifer Flagger. Were there any other statements you took?
I didn't take any written statements. I just talked to a few people at some of the bars, asking if they've heard or seen anything.
Looking for Shane or for Tim?
Yeah, while we were trying to locate Tim Campbell.
Okay. And you didn't note anything about any other people saying anything about the facts of the case?
No, I did not.
All right, so you got there and told the manager you wanted the video?
Yes.
Okay. Any other investigation that you did other than that?
The only other thing that I've done after we collected the video, Shane brought in his medical documentations, and after reviewing it, that's when we updated the charge.
So he came back a second time to your office?
Yes, he did.
You upgraded the charge from what?
To
Objection.
felonies.
Sustain.
You asked him if he wanted a live squad, and he said no.
Yes, he did.
Other than the signs of the cut, the blood on his clothes, you didn't observe any other issues with him, right?
The only thing I observed was just what he stated, the blood, the cut on his ear, his nose. He was pretty scared.
You didn't note that he was scared in your report, did you?
No, I did not.
All right. You took those pictures that we just talked about. He was standing. Mr. Flagler was standing.
Yes.
He didn't have a problem standing normally, right?
No.
You wouldn't have put him in an unsafe situation if he couldn't stand normally.
No.
Okay. You and you don't have any medical training, right?
The only medical training I have is just the basic stuff they gave us in the academy. Normally, whenever someone's injured, we always call 29, which is code for squad. They're the ones who normally provide medical care.
Okay. And that didn't happen in this case?
No, he declined because he said his wife was going to take him to the hospital.
No. But it didn't happen from the VFW either?
Not that I recall.
All right. You made a note. Officer Flora was eventually took him into custody. Is that at your station?
Patrolman Flora is not the one who took him into custody. It was Patrolman Neer.
Near?
Yes.
Was that at the station?
Yes, it was.
Tim drove down there?
I believe so.
Okay. That's all I have, Your Honor.
Redirect.
Patrolman Smith, does 911 actually ring into the Greenfield Police Department?
No. So whenever someone calls 911, it normally goes to Highland County Sheriff's Office, and then they will transfer the call to us. It normally pops up as anonymous or unknown caller, and then the Highland County dispatcher will advise us what's going on, and then the person who's calling will then talk to us.
How close is the hospital in Greenfield to the Greenfield Police Department?
It's not far at all. It's probably close to a mile away.
Is it quicker? Have you driven from the Greenfield Police Department to the hospital?
Numerous times.
Is it pretty quick to get there?
It is.
You didn't note in your report that it was dark outside. Was it dark?
It was dark outside, yes.
Were you wearing this uniform?
Yes, I was.
You didn't note that in your report either. So, are there lots of things that happened that you didn't put in your report?
Yes.
I have no further questions.
Can we step down?
Thank you, Your Honor. Thank you, yours.
Next witness.
No further witnesses. We would move to admit all of our exhibits other than 7, which was not introduced.
I'm sorry.
Ladies and gentlemen, we're going to ask you to retire to the jury room. I'll have to deal with some legal matters. Should be only just a few minutes. And then we'll bring it back. So if you go back there, please. I don't have all the exhibits up here.
The exhibits are already introduced.
Mr. Arnold.
If the court can refresh my memory, my notes indicate, one, the video, the Adena medical records.
Okay, that's exhibits 6.
Yes,
And then Exhibit 7 is the VA medical record.
that was.
I didn't
no-
introduce
no-
those,
I'm sorry.
and I didn't ask to admit those.
Yeah, I know. It's in, I mean, that's the number, but it's not been testified to, so it's not going to be admitted.
Right.
Okay. Any objections to any of the others? The photographs, that would leave the 2 through 5 photographs, 8 and 9 photographs, and the DINA medical records is 6.
No objection.
All right, those will all be admitted. All right, Mr. Arnold, would you like to make a motion?
Yes, just for the record, Your Honor, I move for Rule 29 on this serious physical harm case.
Any response?
Only that that's a decision for the jury to make, and we'd ask the court to overrule and deny the same.
I think that it's a question for the finder of fact, and so as a matter of law, the evidence is sufficient if that is the finding of the jury. All right. Now, you're arresting?
Yes, Your Honor.
Well, obviously you did because I had the Rule 29, but I don't think I officially had you arrested. Okay. So you've arrested, we've made the Rule 29. Now, you're going to call witnesses?
Yeah, there's one that checked in first,
Okay.
so I do.
All right. And then are you going to call the defendant as well?
Yes.
All right. You need a couple minutes to...
I just need to find the witness, unless somebody wants to find him. I don't know where he is. They told him to stay.
Yeah. Let's take 5 minutes and then you go talk to him and get him ready.
Thank you.
All right.
Please rise.
Just say it to him.
Thank you. Be seated, please. Okay, we're back on record on State versus Campbell. The state is rested, ladies and gentlemen, and the court admitted exhibits 1 through 6, 8, and 9. There was no exhibit 7, so that's why it's not there. All right, well, I'll turn now to the defense. You wish to call the first witness?
Yes, Your Honor. Were you Aaron Pence in the hallway right there? Thank you.
Were you sworn in the clerk's office? Okay, would you raise your right hand, please? Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth shall be done? You have a cell phone on you? If so, make sure it's off. Okay. All right. Now, we are streaming this on YouTube, and so photos could be downloaded. Do you have any objection to that? All right. Just have a seat over here then in the witness chair. Now, that's the microphone right there with the red light. If you pull that on that board, it'll slide all the way to your left. Okay. And please come forward and speak into that when you're answering questions. Okay. What's your main point?
Go ahead and state your name. Spell your last name for the record.
Aaron Penn, P-E-N-N.
And do you reside around here?
Live in Greenfield.
Greenfield? Okay. You know Steve Flygore?
Yes.
How do you know him?
Everybody knows Steve Flagger in town.
Okay. On February 15th of this year, did you see him?
Shane, you mean?
Shane, I'm sorry.
Yes. Is that the day of the game?
Yeah, well, the day after Valentine's Day on the 15th.
Yes.
What game were you attending, and who was he attending?
It was a girls' basketball game.
Okay. Varsity?
I think it was reserve and varsity.
Okay. So what time of day was it?
It would have been around noon.
Okay. So they play the reserves, girls, varsity girls, reserve boys. Is that how they do it?
Yes, when they do that, they play the girls, and then they clear the gym, and then the boys come in and play.
Okay. And did you come into contact with him with Shane at the basketball game?
I saw him. I said hello.
Okay.
He said hello back.
And how close were you to him?
Oh, probably 5 feet.
Okay. May I approach the witness, Your Honor?
You may.
Other than the first page of Exhibit A, I'm not going to relabel that to this, but looking at the rest of the pictures in the Exhibit A, Defense Exhibit A, do those fairly and accurately depict the way Shane looked at the basketball game?
Yes.
That's all I have.
Cross?
Mr. Penn, you're the defendant's brother-in-law, aren't you?
Yes.
So you're married to his sister?
Yes.
Okay. And you spoke to Shane briefly at the ball game?
Briefly, yes. Just said hello.
Did you notice the stitches in his ear?
No.
Okay. Did you already know about the beating that he took the night before?
Yes.
Okay. But you didn't see the stitches in his ear?
I saw a scab on its nose.
Okay, but I asked about the stitches in his ear.
No.
Okay. So you were with him 5 feet, but you didn't even notice that?
I did not.
Okay, no further questions.
Redirect?
None, Your Honor.
Okay, you may step down. Thank you. Just leave the exhibit there in the county. To the back. Okay. All right. Thank you. Your next witness?
Yeah, I called Tim Campbell, Your Honor.
Would you stand and raise your right hand? Be sworn. Do you solemnly swear the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. Right, have a seat right there. And then pull the mic in front of you and make sure you speak up and into it.
Okay.
Pull the mic over for you, please.
Oh, I didn't do it. Thank you.
Go ahead and state your name for the record.
Tim Campbell.
And We've heard some and where do you reside now?
I live in Ross County on Cliff Run Road,
And where did you grow up?
Greenfield.
Okay. And what caused you to move to Ross County?
I got a job as a correction officer at RCI,
And what's RCI?
Ross Correctional Institution.
Is that where they have inmates that are jailed?
Yeah. It's a close, like between max and medium, it's a close.
Pretty bad dude.
Yes. Very.
You live in Bainbridge now. When's the first time you ever came into contact with Shane?
First time I ever came into contact, not really contact, but I saw him in the hallway at school.
At the high school?
Yeah.
Okay. And other than seeing him, did you all just pass in the hallways?
Yeah.
On occasion?
Yep.
Did you, other than seeing him at the school, how many times have you ever seen him?
I have only seen Shane the one time at Furman's and the one time at VFW, outside of school.
Tell the jury what happened at Furman's.
We were at Furman's, and me and my fiance were sitting at the bar, and I was looking around like I always do, because PTSD and working as a correction officer, I always want to know what my surroundings are. And Mr. Flagger yelled across and said, "That's my wife you're looking at." And I was like, and I said, "And this is my fiance." And I said, I'm very sorry, but I thought you were gay. Okay. I did say that.
And then did he make any furtive movements or anything, or bow up, or
At
Furman's?
He stood up, took a pretty good defensive posture for a few minutes, and I just turned
But
around.
he was sitting when he said that?
Yes.
At a table?
Yes, behind us.
With some other people?
Yes, correct. Correct.
And then you never saw him again until February 14th?
No, those are the only two times I've ever recall, or I've ever seen him outside of school.
All right. And how long before you punched him, how long had you been at the VFW on the 14th of February?
Probably 45 minutes.
Okay.
Or
And then,
longer.
Why did you go to his table or chair?
I had noticed Shane, and I walked up to Shane, and I said, "Hey, Shane, I would like to apologize for the words we had."
And what was his reaction?
F off, not here. And I was like, I said, "You were going to say something to the wrong person like you're doing in one of these places late at night in a bar like this, and they're probably going to put your head through that wall." That's what I said.
And what did he say after that?
F off.
Okay. Did he make any furtive movements or?
Yes, he did. He turned my way and said F off, like he was getting up.
And then that's when you hit him?
That is correct.
And at the time that you hit him, did you think he was going?
Objection. I put up with the leading for a while, but
Yeah, I'll sustain your leading.
Do you have any injuries to your head?
Yes.
Objection. Relevance.
Sustain.
Can I explain the relevance, Your Honor?
Well, approach.
Instruction provided.
Objection sustained.
I forgot where I was, but I guess we were at the point that you had made a decision to punch him.
After the second time, the way he acted threatening, and due to the fact that I have
Objection.
plates and
Objection.
Wait a minute. I'm going to sustain that and strike that.
All right.
Go ahead.
Leave out the part about.
Objection.
Yeah, we're talking about what happened then. Okay, so let's hear what happened then.
Why did you punch him?
because he came my way and said F off and acted threatening.
So it wasn't just his words?
No, it wasn't just his words.
Okay. Did and then after you hit him, you saw the video. I mean, you don't deny that you hit him, right?
No, I did hit him.
And then you walked away and left.
Right after I hit him, I turned around myself and walked straight out the door.
Okay. And then did you run into the girl, that manager or whatever outside? Or
Not that I recall.
Bartender, the one that testified. You said something.
I think I did run into her.
Do you remember what you said?
I think I said, "Hey, Shane started stuff in their flagger." I said, "I think you might want to go check on him."
Okay. That's all I have.
Cross.
Mr. Campbell, you didn't wait for the cops to show up that evening, did you?
No.
Didn't explain to anyone that you were afraid of Shane, did you?
No.
You didn't explain to anyone that he made a movement towards you, did you?
No.
Didn't tell anyone how afraid you are of him, did you?
No.
In fact, by your words at Furman's, he stands up and makes a posture, you turn back around because you aren't afraid, are you?
I didn't want a confrontation. No.
No, you're not afraid.
No.
Okay.
No.
But you are a bully, aren't you?
No.
You're not employed at ODRC either, are you?
What's ODRC?
Ohio Department of Rehabilitation and Correction. You said you were employed there.
I was
Stop.
employed. I was employed there.
Okay, but you're not.
Not now.
How long ago were you employed there?
2018?
Okay, so you haven't actually worked there for 7 years?
No.
What medicine are you on for your PTSD?
Benefaxline and Prazosin.
You have any kind of diagnosis of that, any kind of medical records of that or anything?
Yes, from the VA. It's no, but it's on my medicine bottles.
And everyone that said that you were just there a few minutes and then made a beeline for him and then hit him, they're all lying. You were there for 45 minutes?
Yes, I was.
So everybody else is lying?
I don't know, but I was there for at least 45 minutes.
Okay. And you hit him just one time and then you backed up and got out?
No. I hit him 3 times and then I turned.
One time?
Yes.
And people had to pull you off?
No.
Well, that's what the video shows. Did you see that video?
Yes, but no.
Overruled.
Mr. Campbell, you don't like to be told no, do you?
I don't understand.
It's just a question. You don't like to be told no, do you?
No.
Okay. No further questions.
Can you tell
Redirect.
I'm sorry. Can you tell the ladies and gentlemen of the jury why you no longer work at the correction facility?
I was assaulted by some inmates and was in the hospital for a while and then on workman's comp for almost 2 years.
All right, thank you.
All right, you may step in. Have any further witnesses?
No, Your Honor.
Defense rest?
We rest, move A and B, Your Honor. Except, I'm sorry, Judge. On A, I was removing the first.
Objection.
Wait a minute.
No.
Wait, let's come up here and we'll do this at the bench. That completes the evidence. So we're going to proceed here in a little while with the closing arguments and instructions of the court. I need to do some review of some legal matters with attorneys before we get to that point. So we're going to give you about a 20-minute break. And we'll need you to either go in the jury room and remain or go outside the jury room and leave the building, walk around for a few minutes, whatever. But don't come back into the jury or to the courtroom until we let you back in. And during that time, you remember the admonitions and instructions of the court not to discuss the matter even among yourselves, not to talk with anyone who's been involved in the case. Also, I'll tell you, and I haven't said that earlier, is that when you go into the jury room for deliberations, you're not permitted to have cell phones or any electronic devices that could communicate outside the room. All communication has to come through the bailiff to the court. So you can either leave your phones in your vehicles or you can put them on the windowsill there. Bailiffs will be watching, and you'll get them back immediately after the case is completed, whichever you prefer. All right, so it is now 2:30. So be back at 2:50, 20 minutes. Thank you.
Please rise.
Counsel, you remain. I'll go back and get this. Be back out. Okay, this, you may be seated. This CD that has Adina, that's part of the Exhibit 6?
Yes, Your Honor.
All right. Make sure I put that together then.
I'm sorry, Your Honor. I did.
There was a CD with it. That's just, I think, is what on here is what it is. So it's in the record, but it's not. They're not going to be able to look at it because they're not going to have their devices. Actually, we'll leave that out because Exhibit 6, the paperwork's all thing you showed them. Actually, you didn't even show them the CD.
The CD is not paperwork anyway. It's the CAT scans that the doctor testified about.
Oh, well, okay. I don't need to see that. I don't know if they'd understand it. I know I would. Yeah. Okay. Now, as far as requests for jury instructions, your instruction, you submit as a proposed jury instruction, Mr. Arnold, and I noticed that on the very first one, 40901, that you listed a number 6, equal weight, direct and circumstantial evidence or equal weight. That's not part of the OJI instruction. I don't know where that came from. But, of course, not going to give it because I think that would be a question of, I don't know whether the direct and circumstantial evidence in this case are of equal weight. That is a question for a jury. And so for the court to say that would be, I think, invading the province of the jury. So I'm not going to give that one. Now let's talk about lesser included. You obviously are requesting lesser included on 2903-13A. which would be knowingly causing physical harm. And is the state objecting to that?
Not necessarily judging it.
Well, I'm going to give it, but I just want to know if you want to put on the record.
No, I don't object to that, but I object to the
Second one.
The second one.
Right. And I'll bring that up then, Mr. Arnold. You're still requesting Part B of 2903-13, the recklessly causing serious physical harm?
Well, that's just what the statute says.
Well, yeah, but it's the evidence. I don't know if the evidence fits.
Yeah.
Yeah.
You can take it out. I don't care.
Okay. I'm going to give it on the A section because I think the legitimate argument can be made as to whether or not this is serious physical harm. So I think that'll be it. Okay. So the instructions I gave you earlier on the second draft, I'm going to strike out the second lesser offense under Part B. And then starting at bottom 11, I'll just say, distinguished by failure to prove beyond reasonable doubt serious physical harm, but did prove physical harm. And then, so the part that had been included under B, that starts at page 15 down through top of 17, that would be stricken. All right. Now, before we get into editing and corrections, and are there any other requests for any other instructions from the defense?
No, Your Honor. I would just. Are you wanting to comment on what your final version or not?
Yeah.
I just wanted to bring it up. I don't know how you want to handle it. There was no expert testimony in this case, and there is an expert testimony instruction. I mean, I just wanted to bring that up.
Okay. Yeah, I think that's true. Yeah, he testified as a fact witness. Mm-hmm. All right.
Yeah.
So that would be on page 3. That part would be stricken. All right. And any other requests for instructions beyond that I gave you in the drafts?
No, Your Honor.
All right. State have any other requests for instructions?
Not requests for instructions.
All right. Objections?
The self-defense. I think that the state met its burden of proof in its case in chief. This was not in self-defense, and I don't believe that's been overcome in the defense's case, in their case. So I object to a self-defense instruction at all.
Well, I'll have to say this is one of the weakest self-defense cases I've ever seen. However, there was some evidence introduced by Mr. Campbell making a claim. Mr. Flagler disputes that. There's no other witnesses that said Mr. Flagler made any threat. It's words only. Well, he said he's kind of turned as if he was going to get up, not that he did get up. And like I said, I think it's pretty weak, but I think that's a question for the jury. So I think that the court's required to let them consider it, and certainly will make for a lot of argument. All right. Any other objections? B. Yeah, B is admitted. Yeah. I gave you A. A is not admitted, so you'll separate that, put it in an envelope.
We didn't have anything here, no.
Right. All right. So then let's go to the jury instructions. Any mistakes or cut and paste errors or other things that looks like I left out something? Yeah, I'll start with Miss Collins and her eagle eye.
So I took it home over the weekend and had a few things. Go ahead.
Now, did I give you the second draft before Friday?
I didn't have time to compare the two, but I will tell you a few things that I'm not sure if.
Yeah, I don't think I did get it to you because I don't think I got it done till like 4:00 in the afternoon. But go ahead.
On On page 8, let's see if this is different, where it says at fault.
Wait, let me get there. All right, at fault, okay.
The defendant did not act in, it should be self-defense.
Yes.
Yeah.
Okay, thank you.
I agree.
Yeah.
At the top of the page, and I'm not sure if it makes any difference or not, but it says a person is allowed to use non-deadly force in defense of another.
Wait a minute. Which page? Up at the top of
It's
page?
different. Never mind, it's been fixed already.
Okay.
It should say in self-defense.
Yeah.
Yeah, I think I saw what you said. I was in defense of another because I took it from the Miller case.
I thought so.
Yeah. And I found that fixed.
Now it says in defense, and it should
Self-defense, yep.
It should be in self-defense.
Mm-hmm. Yeah, that's at the top of the page. All right.
Anything else? There were some problems with the reckless reckless assault, but we're taking that out. So
Right.
that's it. That's all I found.
All right, Mr. Arnold, did
I'm
you have any
satisfied,
other
Your Honor.
things? Okay. All right, and then here we'll be giving them 2 verdict forms, so I will make the changes on that. So it'll be either not guilty, verdict form on felonious assault, guilty or not guilty, and assault, if there's a not guilty finding or they're not able to agree on felonious assault. So I have those there if you want to look at those. All right, and so I'll need to make changes then to the last part of the charges regarding the verdict forms. And that should say count 1, not count 2. And it's still so there will be 2 forms if they find him not guilty of felonious assault and consider assault. So I'll reword that to say that if they find him guilty of this felonious assault, they only complete that. If they find him not guilty of felonious assault, they're to complete that and then consider assault. And in that case, they would have 2 verdict forms. To complete. Okay. And then if they're unable to reach a verdict on felonious assault, if they do convict him on assault, then they would fill that one out. So I'll go back and make that change and bring it back out here to have you review. You can open the door and let the jurors back in the jury room. And once we have all of them back there, I'll come back on the record and go over the language on the last part. So,
Please rise.
What time do you want us back, Judge?
Admitted exhibits. They're to be back here in about 10 minutes, 2:50, so about 10 minutes. Get them copies, please. Yes. Council, I want to direct your attention to the deliberative instructions where I changed the language regarding the number of verdict forms and see how that looks to you.
Where is it, Judge?
Under the deliberative instructions after break for closing argument, be about page 16 or something like that. Actually, it starts at 14. And the language particularly that I changed, it starts at page 16. That's where I'm talking about. Yeah, under verdict forms. So I changed that. I had, for some reason, I had counts 1, 2, and 3, I guess, because I was thinking about numbers of verdict forms, but they're both count 1. And then I deleted the one about the second part of the assault. And then the next paragraph explains the number of verdict forms that have to complete. Depends on the findings, of course. But in this case, it could be 2, could be 1, or 2, depending on the findings.
The verdict form is not going to give them the option of finding not guilty?
Yeah, it's guilty or not guilty. It's blank space. They'll fill in the verdict. So if they find him not guilty, they'll write not guilty on the form. If they find guilty, they'll write it.
Okay. I'm sorry. Yeah.
I'll let them do that. Yeah. Okay. Any objections then to the final version of the jury instructions, or any other corrections?
No, Your Honor.
No, Your Honor.
All right. Bring in the jury then. I don't put any particular time limit on Mr. Arnold, but if I think you're meandering or being repetitive, I'll maybe say something or try to catch your attention. You go ahead and see.
That's the same.
That's the same.
Go ahead and be seated. Thank you. All right, ladies and gentlemen, you've heard the evidence, and now it's the duty of the court to instruct you as to the matters of law. Now, the court and the jury have separate functions. You decide the disputed facts. The court provides the instructions of law. Now, ladies and gentlemen, it's your sworn duty to accept these instructions and to apply the law as it is given to you. You're not permitted to change the law or apply your own conception of what you think the law should be. All criminal cases begin with the filing of an indictment. The indictment informs the defendant that he or she has been charged with an offense. The fact that it was filed may not be considered for any purpose. A plea of not guilty is a denial of the charge and puts into issue all the essential elements of the offense. The defendant is presumed innocent until his guilt is established beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offense that has been charged in the indictment. Now, reasonable doubt is present when the jurors, after they have carefully considered all and compared all the evidence, cannot say that they are firmly convinced of the truth of the charge. It's a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of the person's own affairs. Now, ladies and gentlemen, you're the sole judges of the facts, the credibility of the witnesses that were presented, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witness. You will apply the test of truthfulness that you apply in your daily lives. These tests include the appearance of each witness upon the stand and their manner of testifying, the reasonableness of the testimony, the opportunity that they had to see, hear, and know the things concerning which they testified, their accuracy of memory, their frankness, their lack of it, their intelligence, their interest, and bias, if any, together with all the facts and circumstances surrounding the testimony. Applying these tests, you will assign to the testimony of each witness such weight as you deem proper. You're not required to believe the testimony of any witness simply because that witness was placed under oath. You may believe or disbelieve all or any part of the testimony. You will determine what testimony is worthy of belief and what testimony is not worthy of belief. The testimony of a defendant is to be weighed by the same rules that apply to other witnesses. Each witness was subject to direct examination by the party who called them and to cross-examination by the opposite party. During cross-examination, counsel was able to inquire into some matters that did not directly relate to the issues before the court. Such questions and answers are permitted for the purpose of helping you determine credibility and the weight to be given to the testimony for no other purpose. Now, ladies and gentlemen, evidence is all of the testimony that was received from the witnesses and any exhibits that the court has omitted in evidence during the trial. And I've omitted Exhibits 1 through 6 and 8 and 9 for the state and Exhibit B for the defense. And those are the only exhibits that you'll have. Now, evidence may be either direct or it may be circumstantial or it may be both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which they testify. It includes, of course, the exhibits that have been omitted during the trial. Now, circumstantial evidence is proof of facts or circumstances by direct evidence from which you may reasonably infer from the common experience of humankind. To infer or to make an inference is to reach a reasonable conclusion or deduction of facts which you may but are not required to make from the other facts which you have found have been established by direct evidence. Whether an inference is made rests entirely with you. Now, when considering circumstantial evidence, you may not draw one inference from another inference, but you may draw more than one inference from the same facts or circumstances. So, in other words, you cannot stack one inference upon another inference to reach a factual conclusion. If the circumstances create inferences that are consistent with either acquittal or guilt, then the defendant must be acquitted unless the inferences in favor of guilt rise to the level of proof beyond a reasonable doubt. In the absence of direct evidence of a person's guilt, circumstantial evidence by itself may justify finding him guilty if those circumstances are entirely consistent with the defendant's guilt, are wholly inconsistent with any reasonable theory that he is not guilty, and are so convincing as to exclude a reasonable doubt of guilt. Where the evidence is both direct and circumstantial, you must decide whether the combination of the two types of evidence overcomes the presumption of innocence, convinces you beyond a reasonable doubt that the defendant is guilty. Evidence does not include the indictment, the opening statements or closing arguments of counsel, which you'll hear in a few minutes. Opening statements and closing arguments, as the courts indicated previously, are designed to assist you, but they are not evidence. Any statements that may have been stricken by the court that you were told to disregard are not evidence. Must be treated as though you never heard them. You must not speculate why the court sustained any objection to any question or what the answer to that question may have been. You must not draw any inference or speculate on the truth of any suggestion that might be included in a question that was not answered. Now, as I indicated, a number of exhibits have been introduced and testimony relating to them has been introduced and admitted into evidence. You may consider whether those exhibits are the same objects in the same condition as they were originally, and you will determine what weight, if any, the exhibit should receive in light of all the evidence. Now, the law under which the defendant is charged in count 1, which is the sole count of the indictment, is entitled felonious assault and is numbered Ohio Revised Code section 2903.11a1. This law states in pertinent part as follows: no person shall knowingly cause serious physical harm to another. So, ladies and gentlemen, in this case, the defendant is charged in count 1 with felonious assault under this section. Before you can find the defendant guilty of felonious assault, you must find beyond a reasonable doubt that on or about February 14, 2025 in Highland County, Ohio, the defendant knowingly caused serious physical harm to another. So the essential elements of the felonious assault, the crime of felonious assault as charged in count 1 are as follows. 1, that happened on or about February 14, 2025. 2, in Highland County, Ohio. 3, that the defendant did knowingly. 4, caused serious physical harm to another. Now, it's not necessary that the state prove the offense was committed on the exact day as charged in the indictment. It's sufficient to prove that the offense took place on a date reasonably near the date claimed. before we can decide whether the state of Ohio has proved beyond a reasonable doubt all of the essential elements of the offense with which the defendant is charged. We must first decide whether this is the correct county in which this trial should be held. The state must prove beyond a reasonable doubt that all or any part of the offense charged was committed in Highland County, Ohio. Now, a person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result or be of a certain nature. A person has knowledge of circumstances when the person is aware such circumstances probably exist. Since you cannot look into the mind of another, knowledge is determined from all the facts and circumstances and evidence. You will determine from the facts and circumstances whether there existed in the time in the mind of the defendant an awareness of the probability the defendant's actions would cause serious physical harm to another. Proof of motive is not required. The presence or absence of motive is one of the circumstances bearing upon purpose or knowledge. Where an act is a crime, a good motive or purpose is not a defense. Now, the state charges that the act of the defendant caused serious physical harm to another. Cause is an essential element of the offense. Cause is an act or failure to act which in the natural and continuous sequence directly produces the serious physical harm to another, without which it would not have occurred. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act or failure to act. The defendant is also responsible for the natural and foreseeable consequences or results that follow in the ordinary course of events from the act. Serious physical harm to persons means any of the following. A, any mental illness or condition of such gravity as would normally require hospitalization or prolonged psychiatric treatment, or B, any physical harm that carries a substantial risk of death, or C, any physical harm that involves some permanent incapacity, whether partial or total, or some temporary substantial incapacity, or D, any physical harm that involves some permanent disfigurement or involves some temporary serious disfigurement, or E, any physical harm that involves acute pain of such duration as result in substantial suffering, or that involves any degree of prolonged or intractable pain. Now, a person is allowed to use non-deadly force in self-defense. The state must prove beyond a reasonable doubt that the defendant, when using non-deadly force, did not act in self-defense. Non-deadly force means any force that does not carry with it a substantial risk that it will approximately result in the death of a person. To prove that the defendant's use of non-deadly force was not in self-defense, the state must prove beyond a reasonable doubt at least one of the following. That the defendant was at fault in creating the situation giving rise to defendant's use of force against B, which is Mr. Flagler, or the defendant did not have reasonable grounds to believe that he was in imminent or immediate danger of bodily harm, or the defendant did not have an honest belief, even if mistaken, that it was in imminent or immediate danger of bodily harm, or the defendant used unreasonable force. The defendant did not act in self-defense if the state proved beyond a reasonable doubt that the defendant was at fault in creating the situation, incident, or argument that resulted in the injury, and one, that B, Mr. Flagler, did not escalate the situation, incident, or argument by being the first to use or attempt to use non-deadly force, or 2, did not withdraw from the situation, incident, or argument. In deciding whether the defendant had reasonable grounds to believe and an honest belief that he was in imminent, immediate danger of bodily harm, you must put yourself in the position of the defendant with his or her characteristics, his or knowledge or lack of knowledge, and under the circumstances, conditions that surrounded him or her at the time. You must consider the conduct of B and decide whether his acts and words caused the defendant to reasonably and honestly believe he was about to receive bodily harm. Words alone do not justify the use of force. Resort to force is not justified by an abusive language, verbal threats, or other words, no matter how provocative. In determining whether the defendant, in using force in self-defense, reasonably believed the force was necessary to prevent injury, loss, or risk to life or safety, you may not consider the possibility of retreat by the defendant. Substantial risk means a strong possibility as contrasted with a remote or even a significant possibility that a certain result may occur or that certain circumstances may exist. Force means any violence, compulsion, or constraint physically exerted by any means upon or against a person or thing. Now, a person is allowed to use force that is reasonably necessary under the circumstances to protect himself from apparent danger. If you find the defendant proved beyond a reasonable doubt the defendant used more force than reasonably necessary, and the force used was greatly disproportionate to the apparent danger, then the state proved beyond a reasonable doubt the defendant did not act in self-defense. In deciding whether the force used was greatly disproportionate to the apparent danger, you may consider whether the force used shows revenge or a criminal purpose. So if you find the defendant and state proved beyond a reasonable doubt all the essential elements of the offense of felonious assault, and that the state proved beyond a reasonable doubt the defendant did not act in self-defense, your verdict must be guilty according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of felonious assault, or if you find the state failed to prove beyond a reasonable doubt that the defendant did not act in self-defense, then your verdict must be not guilty according to your findings. Now, if the evidence warrants it, you may find the defendant guilty of an offense lesser than that charged in the indictment. However, notwithstanding this right, it's your duty to accept the law as it is given to you by the court, and if the facts and the law warrant a conviction of the offense charged in the indictment of felonious assault, then it is your duty to make such finding uninfluenced by your power to find a lesser offense. This provision is not designed to relieve you from the performance of an unpleasant duty. It is included to prevent a failure of justice if evidence fails to prove the original charge. It does justify a verdict for the lesser offense. So you must first consider the offense of felonious assault charged in the indictment. If you find the state proved beyond a reasonable doubt all the essential elements of the offense of felonious assault, then your verdict will be guilty as charged. However, if you find the state failed to prove beyond a reasonable doubt all of the essential elements of felonious assault, then your verdict must be not guilty. Also, and that they failed to prove that he acted in self-defense. Then your verdict must be not guilty of that offense, and in that case, then you will continue deliberations to decide whether the state has proved beyond a reasonable doubt all of the essential elements of the included offense of assault. Or, if you are unable to agree on a verdict of either guilty or not guilty of felonious assault, then you will continue to deliberate to decide whether the state proved beyond a reasonable doubt all the essential elements of the lesser included offense of assault, and that the defendant did not act in self-defense. Now, the offense of assault is included within the offense of felonious assault in the indictment. Assault differs from the offense of felonious assault in that if the state failed to prove beyond a reasonable doubt that the offense resulted in serious physical harm, it did prove that it resulted in physical harm, and that the defendant did not act in self-defense, then the defendant could be convicted of assault under our revised code section 2903.13a. So the offense of assault is number 2903.13, and paragraph A of that law states in pertinent part, no person shall knowingly cause physical harm to another. So before you can find the defendant guilty of assault, you must find beyond a reasonable doubt that on or about February 14, 2025, in Highland County, Ohio, the defendant knowingly caused physical harm to another. So the essential elements of 2903.13a are that the act occurred on or about February 14, 2025, in Highland County, Ohio. The defendant acted knowingly, and the defendant caused serious physical harm to another. So the definitions regarding the first three elements are the same as in felonious assault, and I won't repeat those. So the definition of physical harm. Physical harm to persons means any injury, illness, or other physiological impairment, regardless of gravity or duration. So if you find the state proved beyond a reasonable doubt all the essential elements of the offense of assault under RC 2903.13a, and the state proved beyond a reasonable doubt the defendant did not act in self-defense, your verdict must be guilty according to your findings. If you find the state failed to prove beyond a reasonable doubt any one or more of the elements of the offense of assault under 2903.13a, the revised code, or if you find the state failed to prove beyond a reasonable doubt the defendant did not act in self-defense, then your verdict must be not guilty according to your findings. All right, so that completes the instructions on the law regarding the evidence and the offense. I will tell you that I have to make some changes. As you saw, I was writing those in as I was talking. And then once I do, those will be submitted to you in writing so that you'll be able to refer to that instead of, because I know it's a lot to take in a short period of time. Even us lawyers have trouble sometimes remembering it, so you'll have that in there during your deliberations to refer to. so you can put your mind at ease if that was a concern. All right. Now, at this time, we're going to hear closing arguments. Closing arguments are not evidence, but they're simply each attorney's opinion of what they believe the evidence has shown. And the state, since it has the burden of proof, goes first, and then they also present a rebuttal argument at the end of the defense's argument. So at this time, I'll call on Ms. Collins for the state.
Thank you. May it please the court, defense counsel, ladies and gentlemen of the jury, I first want to thank you for your time and attention to this very serious matter, and I know we've moved quickly today, but this is a serious case. Our country is one of the few in the world that uses a jury system to decide guilt. That only works because of citizens like yourselves who take your civic duties seriously. And so for that, I want to sincerely thank you on behalf of my office, the Greenfield Police Department, and Mr. Flieger. Now, I told you when we started the trial this morning, the state would prove that the defendant, Tim Campbell, did cause serious physical harm to Shane Flieger, and we've proven exactly that today. On February 14th, 2025, Shane and Jennifer, members of the VFW, were at the VFW enjoying a quiet night with other members of the VFW in Greenfield and Highland County. While they were there, Shane was sitting at a corner table with his back against the wall. Tim Campbell, this defendant, walked in. He ordered a drink and then made a beeline for Shane and basically picked up where their previous interactions had left off, with this defendant bullying Shane, making fun of him, making fun of his uniform, calling him gay, calling him a faggot, and going on and on and on. When Shane tried to explain, hey, this isn't the place for this, I don't want to talk to you about this, if you want to talk about this someplace else, we will, but not here, not now, not the time, not the place. You know how he is. He said, I don't like to be told no. What's he do? He immediately starts hitting Shane. I'm going to bash your fucking head through the wall, and that's exactly what he tried to do. He hit him repeatedly. He hit him so hard and so many times that he knocked Shane out of the chair and beat him to the point of unconsciousness. He hit him with his fists so hard that he had to get stitches in his ear. He broke his nose, had an abrasion, sprained his neck because his head was bouncing off the wall behind him. This defendant only stopped beating Shane in the face and head when other patrons of the VFW rushed over and pulled him off. Shane didn't move even then. He had lost consciousness, and he was bleeding from his face, head, and ears. He suffered a broken nose. The cut in his ear had to be stitched closed. And he was beat with such force that his neck was sprained. The entire attack was seen by witnesses and is on video. At no point did this defendant, this man who was super focused on Shane, act in self-defense. I repeat, at no point did this defendant act in self-defense. The idea that this defendant was threatened by Shane is laughable. Shane was sitting in a chair. This defendant was standing. And every witness that saw the attack from beginning to end all agree on one thing. They all agree that Shane did not move. I repeat, every witness that saw this attack from beginning to end all agree on one thing. Shane did not move. Words alone are not enough to justify the use of force. That's in your jury instructions. That is the law. So even if Shane had said something that was offensive to this defendant, that's not grounds for him to start pummeling him in the face. Ladies and gentlemen, the state has proven each element of the offense of felonious assault beyond a reasonable doubt, and I'm asking that you find this defendant guilty of felonious assault. Thank you.
All right, thank you. Mr. Arnold, on behalf of the defendant.
Yes, Your Honor. Counsel, Your Honor, ladies and gentlemen, I agree. I thank you for your service. It's very important, and it is a very serious matter. You've heard all the facts regarding what happened 2 months prior to this event on the February 14th. There's a dispute, obviously, of the facts, where one party says one thing, the other party says another as to exactly what occurred. But there's no doubt that the term gay or something was used at that. So when Mr. Flygore was at the VFW, again, this was a private party, got to come through a locked door. Certainly, if anybody was expecting any problems out of anybody, they wouldn't let them in. But there is a dispute as to what was said at that table, but I think you've heard all the evidence that it was loud, bands playing, packed, can't hear anything. So exactly what was said back and forth. Again, one party says one thing, one party says the other. None of them said, I definitely heard exactly what was said. None of them testified as to what was said. The most important part of this, one, obviously, the judge is going to instruct you on self-defense. But keep in mind what Mr. Flygore said at the VFW. This is not the time or place to discuss our dispute. Now, where else would two veterans talk about a dispute than the VFW, right? He's inviting him to do something, go somewhere else. Is he going outside? Where's the better place to do it than the VFW, right? So this happens. I don't dispute that my client punched him 3 times and that he had the scratch on his nose, the stitches in the ear, and a broken bone, which didn't require any treatment. To describe this as bashing his head in a wall is exaggeration, number one, and making a mountain out of a molehill. All right? You're going to have our Exhibit B, which is the doctor's notes. The only doctor you heard from in this case sat right there and said, and you can read the notes, he never mentioned any pain in the back of his head. He didn't mention, the doctor didn't find anything abnormal about his head. No lumps, no bruises, no black eyes, nothing. So if that's a beat down, wasn't a very good one. So you're going to get a chance. The other thing is serious physical harm in this case. You're going to read the instructions, but one of those the judge read to you. No acute pain. How many times did I ask Dr. Barker? There was no acute this, no acute that. Look at Exhibit B. There wasn't any. This is the day of. You haven't heard one doctor, seen one medical record of anything after February the 14th. So what you're limited to is the broken nose, which doesn't require any medical treatment in this case. The stitch, there's no testimony this is a permanent disfigurement. We just said it would heal. Get the stitches out in 10, 14 days. And you did hear evidence from Mr. Flygore that he has, and Dr. Parker, he has prior neck problems. Okay? Anybody with neck problems knows you have neck problems. I mean, to suggest that there's not even pain in it on that day. There was tenderness and spasms, similar to a car accident or whiplash type motion. But that's not serious physical harm. He didn't cause degeneration of his neck. In fact, he couldn't even know that he had that condition. You also heard from Mr. Flygore that he's on drugs for anxiety. And he wants to come in and say something about his concussion and he couldn't sleep and all that. He's already on medications, but you haven't heard from one doctor to relate any condition other than those 4 things: the neck, the nose, stitches, and the scratch to this fight. My client didn't use a pull stick. He didn't grab a beer bottle.
Objection.
Okay, I'm going to sustain that. This is not a case involving a deadly weapon. It's involving physical violence. So limit your argument to that issue.
So, we know the facts. Use his hands. So the seriousness of these injuries don't rise to a long basis. I can tell you. And the medical records and evidence don't. And the most important of your affairs, you would want to hear more. You would want to hear from a doctor about anything. You would want to see medical records. That's the most important of your affairs. and that's reasonable doubt beyond it. If you find that the state proved the case by a preponderance or way the evidence more likely than not, you got to find my client not guilty. You think the evidence was clear and convincing? Not guilty. It's got to be beyond a reasonable doubt. And you'll see the definition of reasonable doubt. Keep in mind that the only medical record is, at the time that night, is there was no facial deformities other than the scratches, no nose deformity. It wasn't crooked or sticking out. These are all things, cracked nose, a stitch. Those things don't require hospitalization. And there's no testimony that it does. He went to the hospital. But just keep in mind, nobody even called 911. There's no evidence of it. Nobody got an ambulance there to pick him up off the floor after he's been sitting there and all these concussions, whatever it is. I mean, they went back in that back room, they said, for a while, to clean up, and then nobody got an ambulance there. I don't doubt there was a lot of blood. I mean, anybody's got popped in the nose or out there, it bleeds. Plus, he had that cut on his ear. That's going to bleed until it stops. But anyway, not even a black eye. He didn't even have a black eye. If this was so bad of a beatdown, you got no soreness, pain, lumps, or anything on the back of his head, he has no black eye. That's not serious physical harm. In fact, it's just the opposite. I agree it's physical harm. I'm hoping that's where you get if you don't find self-defense. But I know there's some argument that my client started the altercation. I don't think that going over to apologize is starting an altercation. Okay, and I do think when you read the instructions and you put yourself in the mind of Tim, who testified, told you he'd been previously assaulted. He's always looking around, and paranoia or whatever it is. And then that this gentleman, Mr. Flagger, on one other occasion confronted him about looking at his wife at that restaurant, at Furman's. Now, you've heard some different dates and times, and one person said it was a year prior. I don't know, but at the end of the day, something happened there. Something caused him to call him gay. And just, I find it hard to believe that guy's just going to walk by and say he looked gay. The guy confronted him about looking around at his wife. So this is not just a words case. This is words plus actions. Tim testified that in that chair, and you can't see it on the video because Tim's back's to the camera, but he was in a chair. They're about the same height in the chair and the standing, if you watch the video again. When he was saying what he was saying, began to turn in the chair, and that's when he hit him. And certainly he testified and told you that he didn't want to get hit. So at the end of the day, I'm going to ask you to find Tim not guilty of felonious assault. This is assuming that any of his actions were not in self-defense. If you find that they failed to prove beyond a reasonable doubt that in his mind he was going to encounter physical harm, obviously you find him not guilty. If you don't find self-defense, I'm going to ask you to find him not guilty on the felonious assault. Then you're going to proceed, as the judge just indicated, to whether or not they prove the case of assault beyond a reasonable doubt, which is physical harm that he knowingly caused. And I mean, he did cause a broken nose, a cut on his ear. The whole neck thing is, there's no medical testimony that's related to this accident, or to rule out that it was from his prior condition. So that's where I'm going to be at the end of this case. I'm going to ask you, or thank you again for your service. If you stay strong, if you feel one way or the other with your convictions on what you're going to, what you think the evidence did show or what it didn't show. And I thank you on behalf of Tim and myself. Thank you.
Thank you, Mr. Arnold. Ms. Paul, on behalf of the state.
I want to talk about I want to address a few things that Mr. Arnold said in his closing. The first is this acute distress, and I'm not going to go through everything that, did he have congestion? No, he didn't have a cold. We aren't alleging that he had a cold. I'm not going to go through everything in the medical records that wasn't wrong with Shane, but he makes a big deal out of this acute distress, and if you remember, I asked Dr. Barker when he was on the stand, what is that? Like, what is acute distress? Well, I already knew what it was. It's serious. It's like gonna die. It's a heart attack. It is, I even said if he comes in with a sharp bite to his leg, but he's doing okay otherwise, is he in acute distress? Are you going to list something wrong with his head? Nope. This is the absolute, we've got to do something now or this person's going to die. We aren't alleging that. So, no, it's not on the medical records. We aren't alleging that was a problem. And again, I'm not going to go through everything that did not apply. I'm also going to note in Mr. Barker's testimony, or Dr. Barker's testimony was this. The doctor sees, we use the word pain, they use the word tenderness. He said it's the same thing to him. He put tenderness in his report, and I think that most medical professionals do, but he said it's pain. He acknowledged that. I said, what's the difference? He said there is no difference in the word pain and tenderness to him. So when he would have put that in his report, he meant the same thing. And that was his testimony, if you remember that from this morning. The defense wants to make a big deal about, 911 wasn't called, there's no ambulance. Well, if you remember Jennifer Flieger's testimony, she was a combat medic in the military. That was her service to this country. Then she also worked on an ambulance. So she's as good, if not better, as an EMT that you're going to call and get when you call 911. Plus, she's already there. She's got him in the car. It's quicker for her to drive Shane to the hospital than it is to wait for the ambulance to come. Everybody that, both Patrolman Smith, Shane, and Jennifer all testified it was quicker for her to drive him to the hospital than it was to call 911 and wait for an ambulance to come get him. And again, she's as good, if not better, than any EMT. She's had training in this. She knows what's up. She was a combat medic, and she worked as an EMT. Now, the next thing that Mr. Arnold talked about was how his client suffers from PTSD. He's afraid, this and that. Well, I don't know if you noticed this during the testimony today, but every time Shane is out, he says, or whenever a witness sees him, his back was against the wall, his back was against the wall, his back was against the wall. He truly puts himself in a position where there's nothing behind him. That is a sign of PTSD. This defendant sitting at the bar at Furman's during one of the incidents has his back to the bar, turns around, makes fun of Shane, calls Shane a faggot, says something like that, turns back around. He's not afraid of what's behind him. He told you, he's not afraid. That was his testimony today. Now, one of your, as the court has told you, one of your main jobs is to weigh the credibility of the witnesses. And you use this the same way you judge the credibility of the people that you deal with every single day. Really importantly, who has an interest in a bias in this case? Who has something to gain? Who has something to lose? Well, the state produced 12 witnesses for you today. A lot in a day, I know. Rhonda said, basically, she testified that she got the video. Dondi heard the defendant say as he was leaving that he just beat the fuck out of somebody inside. Dorothy saw the defendant hit the victim. Chuck saw the defendant hit the victim and noted that Shane did not move prior to this defendant hitting him. Angela Hurlis saw the defendant hit the victim and noted that the victim did not move prior to this defendant hitting him. Shane and Jennifer. Jennifer was in the bathroom when this particular attack happened, but she testified to the Furman's incident when the defendant approached Shane and said some really nasty things. Shane also testified, and Jennifer agreed with this. She left her drink with Shane. He had their drinks in his hands. Now, how is he going to make a movement or hit this defendant when he's holding 2 drinks in his hand? It's ridiculous. It didn't happen. Nobody testified to that. Of all the people that were in the bar that night and saw this happen, the only person that testified that Shane moved is this defendant. The only person that has something to gain from being untruthful, the only person with a bias, the only person with a reason to lie, this defendant. Brandy Tate, she testified that she saw this, and she was at the table, like right in front of this when it was happening, heard, the defendant say something about Shane being the faggot, turned around because it caught her attention, and saw the defendant start hitting Shane, and said also, Shane did not move. Shane didn't lunge at him. He didn't move. She's the witness that testified his head was bouncing off the wall. And everybody agreed that he hit the floor, was unconscious, was bleeding profusely. You heard from Aaron Penn, who does have an interest and bias in the case. He's the defendant's brother-in-law. He wasn't ever close enough to Shane. He came in today and wanted you to believe that Shane was just fine, but he was never close enough to him to actually even see the stitches in his ear. And you'll see the pictures, they're pretty clear. But it was funny, I said, did you know about the beating that Shane took the night before? Yep, I knew about it already. That was his testimony. The only person that has an interest or a bias in this matter is the defendant himself. And we know from the very beginning, from the night of the attack, from February 14th, that he was the aggressor. And we know he was proud of that because he leaves the VFW and tells Dondi outside, I just beat the fuck out of some guy in there. Think about this. The night that the defendant attacked Shane, this defendant quickly left the VFW. If he were truly acting in self-defense, wouldn't it make sense that he would explain that to the officers? Like, I'm staying and telling my side of this. I'm going to tell them I was acting in self-defense. I was afraid of this guy. It didn't happen. Now, the defense wants you to believe that when the defendant walked up to Shane, that Shane moved and said something that made this defendant fear him for himself so much that he had to beat Shane to unconsciousness. But that's not that was not Tim's testimony. He testified he's not afraid of the victim. He just doesn't like to be told no. And of course, that's not what anyone else in the VFW saw or heard, and it doesn't match the video evidence. In the jury instructions, the state must prove at least one thing in order for you not to consider self-defense. The defendant cannot be the aggressor. If the defendant is the aggressor, no self-defense. There's no question he threw the first punch and he threw every punch after that. There's no question from the witnesses, the victim, and the video evidence, this defendant was the aggressor. The only person that needed defending was Shane. In order to prove that he did not act in self-defense, the state must prove the defendant was the aggressor. Page 7 of your jury instructions. The state must prove that the defendant was at fault in creating the situation. This is exactly what it says on page 7 and 8 of the instructions. If the defendant was at fault in creating the situation, he cannot claim self-defense. There is no question from the witness testimony, the video evidence, even this defendant's own testimony. Every witness agreed Shane did not move. He was sitting down, had a drink in each hand. The defendant walked up to him, and he was so afraid because Shane moved in a threatening manner that he had to beat him to unconsciousness, but that's not what anybody else saw. Every defense that you are permitted to consider is listed in the jury instructions. There is no instruction that allows self-defense because the victim said something that hurts the defendant's feelings. Shane didn't say anything to the defendant other than, leave me alone. This is not the time or the place. I don't want to discuss this. Go. Remember what we talked about in jury voir dire? Sticks and stones may break your bones, but words can never hurt you. Well, words don't allow you to beat someone to the point of unconsciousness either. In fact, the jury instructions actually tell you that. On page 8, it says, words alone do not justify the use of force. Resort to force is not justified by abusive language, verbal threats, or other words, no matter how provocative. So it doesn't matter what Shane said. Does not matter because words alone are not enough to provoke a beating. And think of this. Had the defendant really been in a fight for his safety, he would have immediately began telling people that. What he actually told people was, hey, I just beat some guy's fucking ass. He wasn't scared. He just doesn't like to be told no. And Shane told him, no, I don't want to talk about this with you. Now, the state doesn't have to prove motive, but the motive here is clear. The defendant's a bully. He doesn't like to be told no. He saw Shane as someone that he could bully, calling him gay, calling him a faggot, making fun of his military uniform. And when Shane tells him, hey, I don't want your apology, I don't want an explanation, I don't want to talk to you here, get away from me. A bully who doesn't like to be told no, he decides to beat Shane to the point of unconsciousness, breaking his nose, spraining his neck, and causing him to need stitches. Now, in looking at the elements of the offense charge, the defendant, Tim Campbell, did knowingly cause serious physical harm to Shane Flagler on February 14, 2025. Now, there's no real question that this occurred on February 14th of 2025. No question that it occurred at the VFW in Greenfield, which is in Highland County. So we've proven elements 1 and 2 from the jury instructions. Next, knowingly cause serious physical harm. Did he act knowingly? Well, there's no question. He knew exactly what he was doing. He testified today. Yeah, I knew I was hitting him. No question he knew what he was doing. So yes, he acted knowingly. Cause. The act or failure to act which directly produces serious physical harm to Shane and without which it would not have occurred. That's the definition of cause. Well, you'll see this on page 6 of your jury instructions. The defendant's responsibility is not limited to the immediate and most obvious result of his actions. He is also responsible for the natural and foreseeable consequences or acts that follow from the act. So basically what that means is he's not only responsible for hitting him in the nose and breaking his nose, but that sprain from this, he's responsible for that too. Because that's a foreseeable consequence of punching someone in the nose. So, cause. Prove that. Serious physical harm. Now, serious physical harm is a lengthy definition in your jury instructions. Let's go back and talk about, actually, serious physical harm is defined in your jury instructions on page 6 and 7. And as you read through the definition, you'll see that each definition is separated with the word or. And that's important because it says any mental or condition, blah, 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 or number 2, or number 3. Or number 4, or number 5. I point that out because the state doesn't have to prove each of them. We just have to prove one of them. It's not and, it's or. The jury instructions say any of the following, not all of the following, any of them. And we've easily proven this. So the first one is any mental illness or condition of such gravity as would normally require hospitalization or prolonged psychiatric treatment. Okay, well, Shane suffers from PTSD. He's on anxiety medication for it. This exasperated that, and he's still in counseling. That is prolonged psychiatric treatment. So we have proven number one of serious physical harm. The next one, any physical harm that carries a substantial risk of death. We don't have to prove that one. Number three, any physical harm that involves some permanent incapacity, whether partial or total, or that involves some temporary substantial incapacity. He had temporary substantial incapacity. He had a sprained neck. He had to have stitches. And he has a permanent incapacity. So the fracture in his nose healed, but it took 2 to 3 months is what the doctor testifies it usually takes. It's painful that whole time. But he has PTSD, and that's been exacerbated by this, and it's ongoing. So we've proven this one. Any physical harm that involves some permanent disfigurement or involves some temporary serious disfigurement. Again, broken nose, no, there's no treatment for it. It can't be fixed. So it's a temporary serious disfigurement. But those stitches also. Now, that's painful. And it's in his ear, and it's there. So, again, we've proven this. Any physical harm that involves acute pain of such duration as to result in substantial suffering or involves any degree of prolonged or intractable pain. Again, 2 to 3 months for that nose to heal, and the doctor said, yeah, that hurts. He also said that sprained neck really hurts. And the stitches, they were in an odd place. If you remember him talking about that, because of where the cut was, it's an odd place to put stitches in. So, again, painful. Again, we've proven this. And remember the discussion from jury board here. We talked about, let's talk about some examples of serious physical harm. Stitches, broken bones, fractures. Stuff more than a bruise, but all examples of serious physical harm that we talked about in jury board here. Ladies and gentlemen, we've proven each element of felonious assault. We've proven serious physical harm. Now, the state doesn't have to prove, Now, after you read and understand the instructions and the law and you apply the law to the facts you have learned in court today, there is no reason to consider the lesser crime of assault because, and the jury instructions tell you this, once you find the defendant guilty of felonious assault, you don't have to consider the lesser of regular assault. And we agree that we must prove each and every element beyond a reasonable doubt. But reasonable doubt is doubt based on reason and common sense. It's not doubt beyond any and all possible, doubt. That's not real. It's unattainable. We talked about surgery and would you want a second opinion? Well, we would all want to know 100% for sure with no doubt about a surgery, wouldn't we? But that's not reason and common sense. These are the decisions that you make in your everyday lives. Let's talk about buying a car. Say you want a red SUV. Your budget allows for a payment of $500 and you shop around and you collect the evidence. It's the same as being on a jury. You're collecting evidence. You find a red SUV, it only has 50,000 miles on it, and the payments are going to be about $480 a month. It's everything that you want in a car. All the evidence points to getting the car. Now, there is some remote possible doubt that this is not the perfect car for you, but reasonable doubt based on reason and common sense, has been overcome, and of course you buy the car. Now, the defense, again, wants you to believe that reasonable doubt is some mountain that can't be overcome. But when the facts are as clear as they are in this case, the state welcomes that burden of proof of beyond a reasonable doubt because it's easy to obtain. Doubt based on reason and common sense has been overcome, and the state has proven each and every element of this crime. Ladies and gentlemen, you need to do only one thing in this case, and that is watch the undisputed video evidence. When you see that video, it's obvious that this defendant, and only this defendant, caused serious physical harm to Shane. As you watch, you see the victim sitting in a corner chair at the table. You see the defendant standing in front of Shane, and then you see the defendant hit Shane multiple times. Everyone moves in to pull the defendant off of Shane as Shane is unconscious on the floor. And witnesses all agree that Shane did not move out of that chair prior to the defendant knocking him to the floor. And make no mistake, this was a beating. Shane suffered broken bones, a broken nose, unconsciousness, a sprained neck, bleeding from his ears that had to be repaired with stitches. He suffered PTSD and continues dealing with that today. And why did this defendant attack Shane? Because Shane didn't want to talk about this defendant calling him a faggot. And Shane told him no. And this defendant does not like to be told no. I told you when this trial started that not a single person would support this defendant's story of self-defense, and not a single person did support the story. In this case, this defendant decided that Shane deserved to be beat because he didn't want to talk to him. And this defendant delivered that beating. Ladies and gentlemen, the state has proven this case beyond a reasonable doubt, and now I'm asking you to go into the jury room, review the evidence, remember the testimony, and return the only verdict that makes sense in this case. And that is that Tim Campbell is guilty of felonious assault. Thank you.
All right, thank you. All right, ladies and gentlemen, you've heard the closing arguments of counsel, which, as I advised you before, are not evident. I'll now instruct you on how to complete your verdict, or to deliberate and complete your verdict once you've reached it. Now, you must be uninfluenced by any consideration of any sympathy or prejudice. It's your duty to carefully weigh all of the evidence and decide all the disputed questions of fact, to apply the instructions of the court to your findings, and to render your verdict accordingly. In fulfilling your duties, your efforts must be to arrive at a just verdict. Consider all of the evidence and use your common sense, and make your findings with intelligence and impartiality, without any bias, sympathy, or prejudice, so the state and defendant will feel that their case was fairly and impartially tried. Now, if during the course of the trial the court has said or done anything which you consider an indication of my view of the facts of the case in general, instructed to disregard it, the court has no right in any way to invade and does not desire to invade the province of the jury by indicating the preference between the parties. And the court in this case has not done so, and basically my rulings aren't based on anything other than my interpretation of the law. Now, your initial conduct upon commencing deliberation is a matter of great importance. It's not wise to immediately express a determination or to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position, even if you later decide that you may be or are wrong. Consult with one another, considering each other's views, and deliberate with the objective of reaching an agreement, if you can do so, without disturbing your individual judgment. You must each decide the case for yourself. You should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change your opinion if you find that it's wrong. However, you should not surrender an honest conviction in order to be congenial or to render a verdict solely because of the opinion of the other jurors. And you may not discuss or consider the subject of punishment. In the event you find the defendant guilty, the duty to determine the punishment is placed by law upon the court. Now, when you go to the jury room, your first function will be to select one of your number as a foreperson. That person that you select will preside over your deliberations, but does not have any greater power, nor does that person's vote have any greater importance than anyone else's. Foreperson serves to the purpose of helping you to conduct your deliberations in an orderly manner and give each juror an opportunity to express your opinion. One additional duty of the foreperson is to see that the verdict forms and exhibits and copies of these instructions are returned to the court after you've reached a verdict. Now, the court also, again, as indicated, will place in your possession the exhibits and the verdict forms, and the foreperson will retain possession of those, including the verdicts returned in the courtroom once you've reached your verdict. Now, until your verdict is announced in open court, you're not to disclose to anyone else the status of your deliberations or the nature of your verdicts. Now, this being a criminal case, before it can be said that you have reached a verdict, it's necessary for all 12, and I'll repeat, all 12 of the jurors to agree upon a verdict. So you will have in the jury room, in addition to the exhibits that have been admitted, a copy of these instructions, and there will be 2 verdict forms. And they are printed, they have the case name and number, and they both say verdict count 1. One says felonious assault, the other says assault. And it reads that we, the jury, having been duly impaneled and sworn, find the defendant, Timothy B. Campbell, to be a blank space. And there's a reminder underneath, insert either guilty or not guilty, of felonious assault. and then the second one, the same for assault. Now, this is a little bit complicated, and I'm trying to keep it as, I may have overthought it a little earlier, I'm trying to keep it simple. So I'm going to explain to you, the number of verdict forms that you will complete depends on your verdict. So basically we have two things. First, the state has to prove beyond a reasonable doubt all the elements of the offense charged, or the lesser offense if you find they didn't prove the elements of felonious assault. And then you have to also decide whether the state proved the defendant did not act in self-defense. So, if you prove that if you find the state proved beyond a reasonable doubt all the elements of felonious assault, and that the defendant did not act in self-defense, then your verdict would be guilty, and you'd only complete that form. If you find the state failed to prove beyond a reasonable doubt that the defendant knowingly caused serious physical harm, was charged under felonious assault, but did prove beyond a reasonable doubt that he knowingly caused physical harm and did not act in self-defense, again beyond a reasonable doubt, then it's not guilty of felonious assault and guilty of assault, and you'll complete two forms. Now, if the state did not prove beyond a reasonable doubt the defendant did not act in self-defense, then your verdict's not guilty of felonious assault, and you only fill out that form. Now, there's another possibility. If you're not able to agree whether the state proved beyond reasonable doubt the elements of felonious assault, but they did prove there was no self-defense, that he did not act in self-defense beyond a reasonable doubt, then at that time you would also consider the lesser offense of assault and whether the state proved beyond a reasonable doubt all of those elements and that the defendant did not act in self-defense, then you would complete that form. So the number of forms depends on your verdicts, and that's my attempt to explain it. And I'll have to make a couple of changes because I did actually get that a little bit confused earlier on. I'll make the changes so that it's not there. Now, once you've reached a verdict, or verdicts, depending on your findings, you'll each sign your name in ink on those forms, or 4 more forms, because all 12 of you must agree on a verdict, or you don't have a verdict. Now, once you retire to deliberate, you'll be under the charge of the bailiffs. One will be stationed outside the door. And again, I'll remind you to leave your cell phones on the windowsill as you go in. And they will be they'll ensure your deliberations are not disturbed, but they cannot talk with you about the case. They will be a means of communication with the court. So if you do have any questions or other needs, write them down, knock on the door, and give them to the bailiff. And then after I've reviewed them with counsel, I will respond in writing. Now, I can't promise you we'll be able to give you what you request, but I can promise you it will be fully, carefully considered, and I will respond. Now, one thing that I cannot do, we just had a jury trial last week, and this happened. I'm not allowed, under the law, to answer any questions about anything that's not in evidence. And so, if you send me a question such as, what time did so-and-so get there? One of the other witnesses, let's say, not one of either the defendant or the alleged victim. I can't answer that. If you wonder what time that happened, you have to base it on what's in the evidence. And if there's no evidence, then you're not going to be able to know that. But I cannot give you more evidence or bring back and have more testimony added to the case for you. I'm not permitted to do that. And that's what I'll respond to. And if you have a question about the law, again, you'll have the question, the corrected, and once I finish those, it'll take a couple minutes to do that before they're sent to you. You'll have the instructions. And again, if you ask me a question about the law, I'll most likely will say, okay, we'll look at page whatever, because that's where it is. Don't feel reluctant to do that, because again, these things are complicated, and this will be my fourth version of this since I started working on it last week. Because it just and things change during the trial, and you have to make changes. But you will have that. Now, we do have a video, a cassette, or not cassette, I'm showing my age there, aren't I? A CD. And if you want to view that, then you tell me, and we can't send a laptop back with you because it would have other stuff on there that you shouldn't see, and could also potentially be a means of communication. So what we will do is we'll send a laptop back, the door will be open, the bailiff will set it up, play it for you, and then bring it back out. Because you can't have electronic devices while you're in the jury room. but we'll do it for that purpose if you wish to watch that video. Okay, is there anything further from council?
No, Your Honor.
All right. Now, ladies and gentlemen, I want to thank all of you for your patience and your cooperations and your attentiveness. You've been a very attentive jury, and you can see that the parties are not wasting your time today in presenting the case. Everything was presented fairly quickly and efficiently, but thoroughly. And so each of them had that opportunity to do that, to make sure they presented their case well. All right. Now, with that, our alternates, Ms. Moore and Ms. Bolin. You've sat through and heard everything, but you will not be participating in the verdict deliberations at this time, since everything's gone okay for the first 12. However, you will need to leave your phone number with the bailiff, because if something should happen during deliberations, if one of the first of the 12 has an emergency of some sort and they have to be excused from service, then we will call you in the order that you are altered. So you would get the first call, Ms. Moore, and you would get the second call, Ms. Bullock. And I will tell you that I've had to do this a couple of times in the past few years, and so just prepare. Now, we will have the bailiff call you once there is a verdict. And the reason that's important is this. Until you've been informed by the bailiff that there has been a verdict, you are still under the same obligations as if we were just on a regular recess. You're not to discuss the case with anyone. You're not to do any research on it, to look anything up on the internet. You're not to form any opinions about the matter. Everything I'm instructing you, you still follow. Once you've been told there's a verdict reached and the jury's been discharged, then you will be released from that obligation, and you will be permitted to speak about it with anyone if you want to, and if you don't want to, that's your choice. All right, so if you would please come around this way and leave your phone numbers with the bailiff, and if you had any plans to go out of town tonight, please don't until you hear from us. Okay. All right. So, ladies and gentlemen, leave your cell phones on the windowsill. We'll send back the exhibits and my corrections to the instructions of the verdict form in a few minutes. Thank you. All right, if you just stay close, if you want to go get a cup of coffee or something, leave us your cell phone number. So, okay. We're still on record. Leave. Okay, back on record. State versus Campbell. This is a question from the jury. The defendant's not present, but it's regarding they want to see the video. So I just want to put on about the computer and so forth. Do you feel that you can waive your client's presence for this?
Yes, sir.
All right. So the defendant waived for this. So basically, when we talked about this in chambers, I was informed after I instructed the jury that the laptop that they have here, the prosecutor has here, has nothing else on it. It's not connected to the internet, no email accounts.
Nothing.
Nothing else. It's just all right. And so based on that, and then my intention would be then we would leave the laptop in there for them to use once the bailiff shows them how to use it. So you up to speed on that, Ben?
And Bailey showed Ben how to use it.
All right.
Your Honor, I will need to turn the internet off.
Okay, we want to make sure the internet's turned off because it may try to connect to the Wi-Fi by default. They don't have a password, so yeah, go ahead and you say you did?
I have not yet.
All right, if you would go ahead and do that on, please, Mr. And any objection to that, Mr. Arnold?
No, Your Honor.
Okay. All right, so I'm going to write on this. The message, I told him to write it down, that we, the jury, request to see the video. All right. So I'm going to put in, we are giving you a laptop that is not connected to the internet. The bailiff will instruct you on how to play the video. And it's already in the chute and so forth. Yeah. Is it a CD? No, DVD, I mean. Yeah, okay. Again, my age. All right.
Is it in there already?
It's in here, the case is under here.
Video.
Is that the one that they took back?
It's the one that was in there.
Okay, fine. Are you living? Are you living out here?
Yeah, there's an outlet in there. You know, there's outlets in there, aren't there? I'm sure there are.
Sure. That's a hall. I made it small.
All right, so the response then here is we are giving you a laptop that is not connected to the internet. The bailiff will instruct you on how to play the video, and it will remain with you for that purpose. Do not use it for any other purpose. Is that acceptable?
Yes.
All right. Here, I'm giving it to the bailiff to take back there with them, and Mr. Breno will show them how to operate it. Don't. All right, we're back on the record. State versus Campbell. Court received a message at 5:05 that the jury had reached a verdict. Mr. Reno, if you would ask the jurors to come into the courtroom, please, with the verdict forms. Good. All right. Sampson, I understand you're the foreperson. Has the jury reached a verdict? All right. If you would hand the verdict form to the clerk, please. All right, Mr. Hodson, if you read the verdict, please.
In the Court of Common Pleas, Highland County, Ohio, State of Ohio versus Timothy B. Campbell. Case number 25 CR 51. Verdict, count 1, felonious assault. Ohio Revised Code number 2903.11A1. We, the jury, having been duly impaneled and sworn, find the defendant, Timothy B. Campbell, not guilty of felonious assault, a second-degree felony, as he stands charged in count 1 of the indictment. In the Court of Common Pleas, Highland County, Ohio, State of Ohio versus Timothy B. Campbell. Case number 25 CR 51. Verdict, count 1, assault. Revised Code 2903.13A. We, the jury, having been duly impaneled and sworn, find the defendant, Timothy B. Campbell, guilty of assault, a first-degree misdemeanor, as he stands charged in count 1 of the indictment.
All right, thank you, Mr. Watson. All right, ladies and gentlemen of the jury, you've heard the reading of the verdict. All 12 of you have signed each form. Is this the verdict of each and every one of you as each of the forms, each of the verdicts? All right. Wish the jury poll? No. All right. All right, the court then will accept the findings of the jury and enter a finding of guilty as to assault, not guilty of felonious assault. Ladies and gentlemen, I want to thank you for your service on this matter. As we talked about, this is a high form of public service that you can perform, and you have. We appreciate your being here and honoring that commitment to perform that duty. These are always difficult decisions, and you obviously took a look at the evidence and made your findings according to your belief as to the evidence of the law, and the court appreciates that. So this will complete your service. You will not be subject to being called the rest of this year. You're also exempt for next year. Now, we do have a computer program that says that shouldn't pick you again for jury duty in this county, that should be picked in another county, or if you move, or if you're drawn for federal jury, we can tell them you served here under Ohio law. You're exempt from serving in a state court. Feds are not necessarily required to follow that, although normally they do. So if by chance that should happen, then you should we only had it happen once in 17 years. I've been judged where somebody got picked 2 years in a row, and that was a computer glitch. But if it does happen, just call and let us know. All right. So with that, you can get your cell phones and go ahead and report down to the clerk's office, and then everybody will remain in the courtroom for 5 minutes, and then I'll resume the proceedings.
Please rise.
6. So that's...
All right. The jury has returned a verdict of the lesser offense of assault, a first-degree misdemeanor. Ms. Collins, one question I have, is there going to be an issue as to restitution in this case?
No, I believe that all of Mr. Flagger's medical bills he had insurance, so I think everything's been taken care of.
Okay. All right. Well, with that then, I think we'll go ahead and proceed with sentencing. So, anything from the state? The court will note that Mr. Flagger is present in the courtroom.
Shane, do you want to speak? Well, I would ask for a term of incarceration, even if it is served in the county jail, Your Honor. I am astounded that they didn't find this as to be serious physical harm. I can't imagine being someplace and having someone beat me to the point of unconsciousness and to the point of needing stitches and having a broken nose and a sprained neck, and that not being serious physical harm. That being said, that was their decision, but this is the kind of violence and bullying that cannot be overlooked. To set a precedent that this is okay to do is bad for the county. And there is no evidence at all that Mr. Campbell was acting in self-defense. In fact, he admitted that he just doesn't like to be told no. And the court has experienced this from Mr. Campbell with his fit throwing when he doesn't get his way during a previous hearing when he wasn't getting his way. So based on that, I would ask the court to sentence the defendant to a term of incarceration in the county jail. Thank you.
Mr. Arnold? Mr. Flagger does not wish to make a statement. You can just speak from there.
I'm sorry I wasn't prepared for this, but I did nothing to provoke Mr. Campbell. When this situation happened, my kids let me know that he was a teacher at their school and has taught them. I fear for my safety. I fear for my children's safety. I have deployed 4 times, and my wife's never been afraid. She's never had to deal with me getting hurt until I came home and was attacked by Mr. Campbell. I ask that he please be incarcerated and that we do everything we can to make sure that Mr. Campbell never approaches me, my family, my parents, any of our family, because I do fear retaliation.
Anything else? And for the record, identify yourself.
I just asked that...
This Jennifer Flagger, go ahead.
Sorry?
I just want to make sure it's in the record, your name.
Yes.
Yeah, okay. Go ahead.
I just asked that, like Shane said, that you take into consideration that the other spouse doesn't have to come around the corner and see their spouse on the floor like that. I have to fly to Iraq, and I'm telling you that I was never so scared as I was that night. Just seeing my husband bleeding on the floor for no reason, hearing somebody screaming through a place where we call home to be a that's our safety net as veterans. That Shane's hurt. And I never want anybody else to have to hear that again.
Anything else from the state?
No, Your Honor.
Mr. Arnold?
Your Honor, may I please the court, counsel? Your Honor, I believe, you've heard the facts of this, let's comment on those. My client did serve 6 days incarcerated and has been on house arrest with a no contact order, a restraining order since. I don't know how long that's been, but I would ask that you continue that if you're going to give him any further time, allow him to work, and he can still stay away. But that's where I'm at.
All right, Mr. Campbell, anything you'd like to say?
Yes, sir. I just want to apologize to Mr. Flagger, to everybody else. The jury did find me guilty, my peers did, and I apologize, and I'm sorry everything happened. And I hope things go better for the both of us and everyone, and thank everyone for being here.
Well, in my opinion, this verdict is a result of the law. Next to the definition of recklessly, the definition of serious physical harm is the most poorly worded statute in this criminal code. Because the way I would look at it, would I be willing to trade places and accept the harm that was caused in this case? And I think the answer to that is no. But unfortunately, the way the law was drafted, the jury found that it did not meet that standard. And so, that's the reason we have this verdict that we do. I will say this, Mr. Campbell, I think that you're a liar. I think you're a bully. I think you've got a big mouth. There's no reason for you to go after Mr. Flagger at all. So what if other people in the school didn't like him? I don't know if that's true or not. I don't believe you. So, but even if it were, so what? Why is that your business? Why do you go out and confront him in a bar? If you had to use self-defense, if you're worried about yourself and getting hurt, then you need to start shutting your big mouth and keep it to yourself. But no, you want to go out and show everybody what a tough guy you are, which isn't. You're just a bully. Mr. Flagger walked away. There's no evidence at all in this case that you acted in self-defense, and everybody in this case knows that. The court feels, in order to send a message and make sure, hopefully, that the school revoked and that the Department of Education revoked your credentials as a substitute teacher, because if there's a worse example of somebody to the youth of a school, I don't know who it could be. Maybe a sex offender, but other than that, what you've done is a disgrace. And just walk in there and assault this man, and it dishonors the VFW too, and other organizations. Veterans are supposed to be there for an exchange of fellowship and camaraderie and support of each other, not to go in and attack each other. Or in this case, you attacked him, and totally unprovoked. And I don't believe your story, neither did the jury, for a minute. They found you guilty because of what they believe the law required, and felt that the state had not proved that. So order the court that you be sentenced to 180 days in the county jail. You'll be given credit for 6 days, according to the sheriff. Were arrested on the 24th of February and released,
He was arrested on the 19th.
19th and released on the 24th, so they get credit for 6 days. You're also fined an amount of $1,000. You're also ordered to pay the court costs, which judgment, grant, and execution is ordered. And if you fail to do that, then the clerk can collect that through various means, including levy on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then the court could permit you to do community service in this county and give you credit for each hour of your work. Each hour of your work would reduce your judgment by that amount until paid in full. Now, you do have the right to file an appeal. In this case, Mr. Campbell, if you wish to do that, you'll have to do that within 30 days. If you don't have money to hire an attorney to prosecute the appeal, the court will appoint one for you upon that finding. You're also entitled to have the transcript of proceedings and all the papers in the file, the transcript of the case file. And if you don't have the money to pay for that, the court will also provide that to you upon finding indigency. Your appeal will have to be filed within 30 days of the journalization of the entry in this case, which will probably be tomorrow. All right. Anything further, counsel?
No, Your Honor.
All right. You're remanded to custody.
Please rise.